Good morning, everybody. Happy Wednesday? I think it's Wednesday. Well, we're going to assume it's Wednesday, so happy Wednesday. Welcome to the Courtroom Files Live. Let's start with Judge Dad up in Michigan.
Please. I'd like Shamard and Johnson seated at that table, my right, your left. Your name? That's the right. You have the right to a lawyer. Where were you? Why weren't you here? I said, why weren't you here on August 27th? Did you call the court?
Yes, I did.
Who'd you speak to?
I didn't get a name, and I also.
What'd you tell them?
I told them that I had a family emergency and I needed to reschedule, and I called back the next day, and that's when she told me that my court date was the 10th at 8:40.
What was the family emergency?
My grandfather passed away
That day?
the day before.
I'm sorry. Lisa, do you know if we got a call? Anything indicated in the?
No, but that if they don't call first thing, that would be our normal procedure to just have them come in their next court date.
All right, I'm gonna go ahead and, you waived your right to a lawyer. Brownstown's here today. I'm gonna send you to the Brownstown prosecutor, okay? You go talk to the Brownstown prosecutor, see if you can resolve this. If not, I'll set it for trial, okay?
Okay.
Thank you. Jacob. Where's Shamard and where's Johnson? Jacob Raymond Shamard, 25B149118. Jacob Troy Douglas Johnson, 25B149117. Could I have Patrick, come on up to the podium, guys. Could I have Patrick Caldwell seated at this table, right there, behind them, my right, your left. And Seclawi, same thing, seated at that table, right behind them. Your name, sir?
Jacob Raymond Schumacher.
Your name, sir?
Jacob Troy Douglas Johnson.
All right, so we have open intoxicants in a vehicle. Each of you have the right to a lawyer if you want one. Do you want one, Mr. Shamard? Mr. Johnson?
Yes, Your Honor.
All right, we're gonna have to set them up with two. They're co-defendants, John. So you guys go out in the hall, we'll set you up with a lawyer and you'll come back in here, okay? With your lawyer, Patrick Henry Caldwell. 25B149160, A and B and C. Your name?
Patrick Caldwell.
Okay, Mr. Caldwell, you have the right to a lawyer as well. You're charged with operating while intoxicated, leaving the scene of a property damage accident, and expired license. If you want a lawyer, I'm going to give you one.
Okay.
Would you like a lawyer?
Yeah.
Okay. You can go out in the hallway. We'll get your lawyer and set him or her up with you, and then you'll come back in front of me, okay?
All right,
Thank you. So this one, we need two different lawyers. Because they're co-defendants and then we'll send them to it. Maher Seclawi, 25B149407 A and B. Good morning, sir. Your name? All right, you're charged with drive while license not valid. And expired plate. That's a civil infraction. You have the right to a lawyer. Do you want one?
Sure. Do I need one?
It's up to you. I can arraign you and let you go talk to the prosecutor yourself, or I can get you a lawyer and the lawyer. Nope. You waive your right to a lawyer?
Yes.
I'm going to go ahead and arraign you though. On August 17 of 25, it is alleged that you did operate a motor vehicle on Gibraltar near Ralden, Brownstown at 5:27 p.m. They think you had an invalid license, a misdemeanor punishable by up to 90 days jail, fines 500, costs are all, and then you have a expired plate charge that is a 0-point civil infraction. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights? If you plead guilty at any time, whether now or later, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? You still wish to waive your right to a lawyer? I'm entering a not guilty plea. I'm giving you a $500 personal bond on the misdemeanor. You don't have to post any money. There are bond conditions, though. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You're going to go speak with the prosecutor. I'm sending the file into her. And then either way, you're coming back in front of me today. Okay? Yes, yes, sir. All right. Any questions?
No.
All right. Good luck. Nicholas Edward Gilliland. U5741338 and
Morning.
All right, so you have a bond violation. Is Mr. Baldwin here today, Lisa? Yeah, we're gonna set you up with Mr. Baldwin, okay? So you go out and, pardon?
You're a talk.
Okay, as soon as he's ready, you can go tell him whenever he's ready, I'll call the case, okay? Joel Dean Malnavsky, 258148750, Joel Dean Malnavsky. This is Mr. Crawford's case. Was Mr.
Baldwin's.
This is Baldwin's too?
Yeah, the rotation changed over in September.
Okay, thanks. Is Mr. Malnavsky in here?
Speaking.
Mr. Baldwin, good morning. Mr. Malnavsky, have you spoken to him yet? I've got his sentencing here. If you have,
Oh, hold on. What is the name, Judge?
it's Joel Malnavsky, Malnofski.
He's with me right here. We're coming in.
Okay, I don't want to rush you. If you need more time, no problem.
Just a minute. We're going through the report and we're almost done.
No problem. Take your time.
Thank you.
Thanks. Daniel Michael Godbout. 25B148549C. Counsel, are you a lawyer?
Yes, sir.
Okay, I'm sorry. I thought so. What case are you here on?
Mark Brom, set for 8:30 sentencing.
Pull that out. All right. Your name, sir?
Dan Godbout.
All right. So you're charged with failure to pay fines and costs of $225. If you plead guilty, if you're found guilty, this would be a first technical violation. You could get 5 days. You understand that?
You said, what, remember the first part?
This is a first technical violation. If you
Pay and everything else.
slow down, just let me explain. If you plead guilty, or if you're found guilty, this would be a first technical violation. You could get 5 days jail. Do you understand that? Yes?
Yes.
Did you sign this advice of rights form and read and understand the rights?
Yeah.
If you
Yes.
plead guilty, you will be giving up all those rights. And there will not be a hearing or a trial. Do you understand? Yes?
Yes, yeah.
You have the right to a lawyer.
Mhm.
I'll be happy to provide you with one if you want one at public expense.
I don't understand what this.
Hang on, slow down. Yeah. Okay. I didn't want to get into this conversation. You were supposed to pay $100 a month starting July the 3rd.
Ben pays.
Lisa, I'm showing he paid $100 on September 2nd.
He's here for
That-
prosecutor review and a show cause. That might be why he's confused.
Has he paid? The register does not indicate that he's
He
paid.
paid
everything.
100. He paid 100 on September 2nd and 100 on September 4th.
All right, so you were supposed to pay $100 on July 3rd and $100 on August 3rd.
Well, they sent you.
Listen, I don't want to quarrel with you. I wrote
I
wrote this down. I told you if you didn't have the money to come and talk to me. I told you if you didn't have the money and you came and talked to me, I'd give you extensions. You didn't do either one of those things. So let's not debate whether or not you.
Go ahead.
Thank you. You didn't pay when you were supposed to, according to our records.
The slips.
Would you stop?
The payment.
Would you stop?
What's that?
Sir.
You didn't pay anything until September 2nd. You were supposed to pay starting July 3, then August 3.
The slips they sent me
Sir?
on those days.
Okay, then you want to plead not guilty? You want me to have a hearing? If you do, that's fine. If you think we screwed up over here, I'll be glad to get the probation officer over here. Don't make this bigger than it is.
No, I'm
I
not.
have a process and I'm gonna go through the process.
Mhm.
And it is as I'm telling you. You're either gonna plead guilty, or we're gonna have a hearing, or if you want a lawyer, I'll give you a lawyer. Whatever you want.
I guess I'll just plead guilty because.
You- slow down. Do you waive your right to a lawyer?
That's it.
To the charge you failed to pay your fines and costs as you were ordered to, how do you plead?
Guilty. I am.
Did you, don't guess, this
Yeah,
isn't
yeah.
Jeopardy. You sure, you sure? You think you're guilty?
Yeah, no. Guilty.
You think you're guilty?
Yes, I am.
Did you fail to pay your fines and costs as ordered?
I must have.
Well, you're not convinced. You want to look, you're not convinced.
I just did have a look at the paperwork they sent me.
You were never on okay, you were on probation for 3 months. I placed you on probation because this was going to be taken under 771.1. I'm going to get probation in here. I need Jessica. Okay, have a seat. I'll come back to you, okay?
Good morning once again, everybody. Welcome to the Courtroom Files Live. I have confirmed it actually is Wednesday, so happy Wednesday. I lose track. I'm getting old, I guess. I've got my eyes on 14 different courtrooms already. There's a decent amount going on. We'll ride with Judge McNally for a couple more minutes and then probably see what else is out there.
I'm going to call out the name now. Give me 1 second here. Is there a Giovanni Gaglio or a Mary Gaglio either here or on Zoom? You see any of them on Zoom, Lisa?
No, not on Zoom.
All right, counsel, I referred your client. He pled to leave the scene of a property damage accident. It appears the failure to yield was dismissed. Can I have both of your appearances, please?
Good morning, Your Honor. David Cowan on behalf of Mark Brom, who's in the courtroom today on my left in person.
Sir, your name?
Mark Brom.
All right. Go ahead. What would you like to say? Have you had a chance to review? I need you to wait 1 sec. Have you had a chance to review this report with your client? And are there any material additions, corrections, or deletions?
Yes, Your Honor, we've reviewed both the field case report, the traffic crash report, probation's substance abuse training, and the victim impact statement. We see no material inaccuracies to the report. On September 8th, we submitted a sentencing letter to Your Honor outlining various factors of Mr. Brom's background that we asked this court to consider in rendering a sentence. And as articulated, we fully recognize the way the police report reads in this matter, but we believe there's circumstances that dictate in the big picture that would warrant Mr. Brom not being placed on probation, being ordered cost and for fines, and learning a lesson in this matter. And when the opportunity arrived, Mr. Brom would like to address it.
Okay, sir, go ahead.
First and foremost, I'm very sorry, not only for the victim, but the parents, the family. We didn't want this to happen. I'm very glad to hear the first one to be here. And also, I'm sorry for my wife, who I put this girl to see through. She was helpful and we get nervous and
The only thing that worries me is you said you were drinking there and then you leave the scene, right? You said after a few drinks you left. That's what you told the police. That's more than 2 beers. This was a no contest plea. I'm not going to interrogate you about it. That would be inappropriate. I'm not gonna make an assumption that you were intoxicated. They didn't prove that. I don't know what else to say other than the fact that I see this happen from time to time. And you gotta be careful, is the bottom line, right? So I'm gonna be as reasonable as I can here. I'm gonna place you on probation for 9 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm going to order that you abstain from the use of alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs, and ETG tests. I'm going to make that on demand of probation. I'm not going to order the bi-weekly. Nobody proved you were drunk, but there was enough here where it gives me concern. Kratom, poppy seeds, and CBD oils are prohibited. If you consume food or other items containing those substances, it will be deemed a violation. I'm going to order that you attend a level 1 alcohol education program. It's an educational program. Attend that, complete that, as well as the Victims Impact Panel, which is 1 night. Serve 3 days of community service. I'm going to give you all the way until October. They're recommending court work, but I see you have some health concerns. I'm going to give you all the way until October 31 to do that. There's a $60 screening fee. There's $180 in probation fees. I'm going to order that you pay fines in the amount of $100, costs in the amount of $150. Again, $75 victims' rights fee, $50 justice assessment. So fines and costs here amount to $375. You have a screening fee of $60 for $435. Probation fees of $180. Your total is $615. Restitution, if any, will be handled through little civil litigation. If you violate, you could get 90 days. You have 21 days to appeal again and 14 days to apply for a court-appointed lawyer for purposes of appeal. So do you fully and completely understand the sentence?
Yes.
So $615 you're going to pay through the alcohol education program, Victims Impact, 24 hours community service at any nonprofit by October 31. No alcohol, no marijuana, no illegal drugs, testing on demand, no kratom, no poppy seeds, no CBD oils. Can he pay all of this today, counsel?
Yes.
Okay, and then you'll meet with probation. Nice to have you here, Mr. Cohen.
And
Mr. Cohen, have a good day.
Judge, at some point, is there an opportunity to petition to transfer to unsupervised probation if he's?
You could, if he does everything, you can, he is eligible for early discharge after 4.5 months. So you can petition for that after 4.5 months, so long as he hasn't had any violations in the preceding few days, and there's he's done everything else. Okay? Have a good day. All right, I want Mr. Godbout up here. Daniel Michael Godbout, 25B1485449C. Your name? Sorry, we had to call you over here. Mr. Godbout, your name? Your name?
Dan got it.
He doesn't seem to think he did anything.
So there was an issue with the payment plan. So he has 2 separate cases. So they were applying the fines and costs to the one case and not paying off the probation case first. So we did address it and made the balance towards this one paid. So now he does only owe $25. That's the only thing that's left on his case.
Okay, pull him up. Yeah. So he had a second payment.
Yeah, it looks like he has a ticket that the payment plan was put together, but instead of applying the fines and costs to probation first to pay it off, it went towards the ticket on accident.
All right. So I see. So he owes on the false information. What, Lisa, can you pull up number 2, please? Can you help me with this and tell me what happened if you can tell? Go down.
It's all one case. He made $100 payment on the B case, and then the next two payments went towards the C case, which was probation.
Okay, listen. I'm entering that guilty plea. Do you have the other $25?
Not on me, no. I did another $100 a month. I wish I did, but
I can void that first payment if you want and put 25 on it, because he
No.
is set for prosecutor review today.
Call in Ms. Caitlin Foley Carter, please. How are you supporting yourself?
Social Security.
You gotta pay on the other one, okay? You understand? Well, it shouldn't be. It shouldn't be. We'll give you a printout. If you need more time, no problem. Come talk to me or call the court. We'll go on Zoom. I'll give you an extension. I have no issue. I'll do that 112 times if I need to. Miss Foley Carter, your name? Mr. Godbout here owes $225. That's what I assessed, I should say. He's paid $200. There was a confusion on another file because a payment was applied to the companion case. We issued a show cause. He owes $25. Today is his date for review hearing. He's living on Social Security. Do you want to just move to dismiss this? Will you fill out a form, please? I'm gonna have you take this, and then we'll get you out of here, Mr. Godbout. So you can go talk to the prosecutor real quick, okay? And then we'll get rid of this case. I'm dismissing the show cause, by the way. James Curtis Yandon Jr., 25I-415-116 A and B. I'll be right with you, Mr. Baldwin.
I'll just keep working files, Judge. Thank you.
Okay, let's do that now. I don't see the defense in here. Melnowski, Joel D. Melnowski, 5B48-750.
And good morning, Your Honor. For the record, House Counsel, Attorney Michael, 65417. I'm dead.
Is anybody here, your name, sir?
Joel, speaking.
Is anybody here on this case that's a victim? And I'm referring to Stephen Ernest, Shane Anderson. There's a third vehicle, David Hartman. Any of those individuals here in the courthouse or on Zoom?
No, not on Zoom.
Mr. Melnowski, did we talk about sobriety court with you?
Briefly, it was mentioned, the arraignment.
Mr. Baldwin?
Thank you, Judge. What I did was went over the PSI report. I did not speak to him about. So
I know, and I'm gonna tell you right now, he's got a prior in 23. He drove into 3 parked cars. He's on Xanax. He was under the influence of Xanax and had a 231. And I'm just telling him, if he doesn't get into sobriety court, he's not gonna like what I'm gonna do today.
you consider that? That's good. Can we consider that, Judge?
Yeah, I'll send him over to probation
Yes, please.
to speak to the sobriety court personnel. I don't know if Sadie or Emily will talk to him, but I would like to have,
This,
he can at least understand it. And if he doesn't want to do it, that's fine. He's going to do a few days in jail.
yes, Judge.
If he does want to do it, I'd love to have him. He needs help. So take the probation, John, and have him have them talk to Mr. Melnowski here, okay? Thank you.
Judge, if it please the court, I have a Gilligan.
Nicholas Edward Gilliland, 25U574138A, and I'm going to need Sadie in
I, for the record, Your Honor, House Counsel.
call her if you would, Timothy.
House Counsel Attorney Mike Baldwin, and manage your court release the state forward.
Good morning, Your Honor, Nicholas Gilliland.
So we have a bond violation. How's he going to plead?
Guilty, Your Honor.
If you plead guilty here, your release could be revoked, bond forfeited, and the high cash bond set. Do you understand that, sir?
Yes, sir.
And you understand you have the right to a contested hearing. You have the right to remain silent at that hearing, to question the witnesses at that hearing, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights. And we will not have a hearing of any kind. Do you understand that?
Yes, sir.
All right, knowing all that, if you plead guilty, you're giving up all those rights, there will be no hearing, do you understand them?
Sir.
The charge you fail to refrain from consuming alcohol, testing, or drugs, testing positive for THC, on September 6th of 25, and also signing an admit form reporting your last use on September 1, how do you plead? Did you test positive on that date?
Yes, sir.
Was there a bond condition that prohibited you from consuming THC?
Yes, sir.
Did you do so anyway?
Yes, sir.
Did anybody force you to plead guilty?
No.
All right, I'll accept your plea to testing positive for THC on September 6th. Okay. Good morning. Your name?
Baby Jamie.
Here's the problem. He's still using marijuana. We're not gonna have him in the program if he's using marijuana. You're either gonna have to get off the marijuana or we're not gonna take you into the program. Now, don't lie to me. Tell me when you last used marijuana.
I'm very.
How many other tests has he had other than this one on the 6th since September 1?
I have the number right off the top of my head, but he's been testing positive since it came.
I know, I had that. You've been testing positive. We talked about allowing you into sobriety court and all these tests are coming up positive. Were any negative?
We did have, I think, 2 negative tests, but from what I understand from on site, they said they were faint lines and that they put those down as negatives, so.
Do you want to do the program?
Yes, sir. I mean, I had a long talk with Sadie yesterday. I just wasn't being honest with the court in the beginning and I just had, you know, I got a house I had to take care of a lot and that was all I've ever known is substances since I was 13. You know, this is the first week I've ever been like in my head for once. So I don't want to get, I had a hard time thinking about it. Like it was, I smoked that long in my life. All I like doing is going to work and going to AA and doing what I had to do. Like, it's what keeps me safe, literally. Like I love working. I love being sober. I do. I was sober for 8 months and then I relapsed and caught these cases when I was living next door. Like it was, I was good. I know what I gotta do. It's just, it's all in my body right now. The smoking was, I was trying to stay eating and smoking by smoking and stay sleeping by smoking. Now I'm trying to take melatonin and go to the gym and do everything I gotta do. Like Sadie gave me a lot of advice yesterday. I've just been trying to put it into play. Like it's all I have to do. I want to get this behind me like I had it at one point. I just got in trouble with it.
He's a type A addictive personality. It doesn't matter if it's drugs, alcohol, cookies, whatever it is. He's going to have trouble refraining from the use of it. He's got addictive properties.
Remind me. He's in treatment.
No.
No, that was the other issue. That was him, wasn't it? You're not following through on your treatment.
I missed my intake appointment.
You can't do that.
No. I've been trying to get in again. I've been calling her every day. I called either 2 days ago when I left her Monday and then she told me she was gonna call me back in my appointment. I tried yesterday, Sadie emailed her, she was supposed to call me. I haven't gotten a call yet today, but that was completely my fault. I'm ready, like I had all this behind me and I just was stupid again.
Well, it's not gonna be behind you for 2 years if you're successful here. You understand that?
I want it to be
You
behind.
you hear what I said?
Yeah.
You're gonna be on this program for 2 years. We haven't even started yet. This is just the bond phase. You got to get into treatment. You can't try to cure all this by yourself. Get yourself some help. I'm gonna adjourn it 4 weeks, Lisa. Give me another date when Mr. Baldwin's here.
I think I spoke to Sadie. I think we have a date already planned.
What is it?
October 16th.
All right, I'm adjourning your sentencing to August 16th. I'm reinstating your bonds, October 16th. I'm sorry, October 16th at 8:30 in the morning. And I'm going to reinstate your bond. I don't want to see any more positive tests, and I want you getting into treatment now, okay?
What if my levels are going down?
We're gonna watch it. Trust us. We know what we're doing.
My whole life.
Get into treatment. Stop using. Okay? All right.
There is one other issue.
Uh-oh.
Mr. Gilliland is having trouble paying for the lab testing. He told, on site the other day that he's unable to pay for any more lab testing.
Well, not anymore, like just that day, I didn't have the money on me, like I'm trying to straighten every dollar I can to get it.
Stop buying marijuana then. Listen. We cannot pay for your testing pre-approval into sobriety court. We have grants to do it afterward. That's not gonna be a valid excuse to me. That you can't pay for your testing, so you better figure it out. Go to whoever you need to go to borrow money, do whatever you need to do, get an extra job. I don't know. I don't care. Okay?
Thank you.
Come on. You gotta do this for yourself.
Thanks for believing.
Well, I do, but you gotta follow through, Nick. Go down the hall, get your notice date.
There's one other, I did look into a different at DNA for him. It's called the J99. It's a smaller panel, but it's $15 and it's a lab every time he tests. They'll send it to the lab.
Whatever you guys want to do. If you think that, what, you mean it doesn't cover as many substances?
He's paying $40 3 times a week.
How in the
So.
world is that happening? I thought, hang on.
Only when he orders the lab is he paying.
Yeah,
The confirmation.
yeah.
We aren't having him order it every time. We've been doing it. I've just been emailing him when to order the lab. But this one, this would just go to the lab automatically. And he'd be responsible for $15 every time.
So he wouldn't need to confirm because it goes right to the.
Whatever you guys think.
There's both that option.
I'm fine. Wait.
Official.
If you guys feel that's gonna cover it, I don't have a problem.
Thank you very much.
Okay? Cole Salmons.
So, Austin, I'm with you. The case that keeps going. One more thing. Wait, one more thing. But it's finally done. Let's change it up a little bit. Let's go to Texas Judge Stevens, see what's going on there.
Speak up. So, yeah. I heard you.
$500.
All right, this is going to be a disposition. Does the defendant waive, you were here with Ms. McNally, your attorney, and the state's attorney is here. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about October 20th, 2024, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, and you understand that you're charged with.
Aggravated assault.
We're proceeding on the lesser included, Judge. She did.
I'm just telling you
Yes,
what
sir.
you're indicted. You didn't know you were indicted?
No, she
with
did,
this?
Judge. She repeated back what she was charged with in the indictment to communicate her understanding of what she's charged with.
I thought she was the court questioning, which this is a second-degree felony as indicted.
Limitations on.
Judge, I need to swear her in and fingerprint before we go.
Go over there.
Well. My food, so. This I hope.
You didn't, ma'am, you didn't know what the indictment said?
I'm not even with aggravated.
He has to,
He
has to admonish you with what you're charged with in the indictment, and then on the plea agreement with what we agreed to is the lesser included class A assault with bodily.
That's why.
So he just has to go through his list of informing you of everything and to proceed on the lesser included. The plea that we've come to.
Okay.
Ma'am, please raise your right hand and swear or affirm to pledge the whole truth and nothing but the truth, so help you God.
It's.
Okay. We have your right thumbprint. Okay, place it flat right there.
Doesn't have to end up that way.
Ink it up one more time.
He works at the school.
Okay,
Let's drop it.
place it flat right here. We'll stand for another judge.
Take your hands out of the.
All right, we're back.
Out of the area. You know, I'm just.
Let me get the pad here when she's
This
through.
one's thrown an error. I'm gonna give you another one.
Okay, this is it's indicted as a second degree felony, which carries with it up to 20 years in prison. What I have here is lesser included what?
Assault, class A. Charge.
It's on the third page, Your Honor, written in.
He likes to write it in, it's a top charge.
Yeah, no, nobody looks past the first page here. They were looking at this.
Drawing. It's gonna be a bottom.
Okay, class A misdemeanor assault is the lesser included offense, which is you intentionally, knowingly, or recklessly cause bodily injury to another person. That carries with it up to 1 year in the county jail and or up to $4,000 fine, or both. County confinement up to 1 year and $4,000 fine. You understand what you're facing here?
Yes.
Agreement's been reached further. You would be pleading guilty, placed on deferred or unadjudicated probation for 2 years, a fine $500.
There's no restitution. They sent back in a sheet that said they weren't requesting any.
Who paid for it? That cost. I mean, he had to go to the hospital and had some kind of surgery. Well, it's not the taxpayers.
No, it's insurance. He had insurance, but it just, he put down the amount in terms of loss he's requesting. He said there's nothing as blank as there's zero. So he's not requesting any, and
Okay, the complainant in this case is Aiden Williams. Did you know him at all? No? No, at all. All right. Is this your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this? Lesser included class A misdemeanor of assault, guilty or not guilty?
Guilty.
You can't touch any of this or else it exits. Are you pleading guilty voluntarily and because you are guilty?
Yes.
Okay, I'm just going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney?
Yes.
You have to speak out?
Yes.
Okay. Is everything true and correct there?
Yes.
Okay. State's Exhibit 1 tendered into evidence. Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know, to this lesser included class A misdemeanor. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime in any lesser included offenses, such as this class A misdemeanor. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1. It is part of the record for all purposes. Pre-sentence reports away.
Yes, Judge.
I'm going to follow this agreement if nothing further. And I'm going to find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. Even though there's enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty, I'm going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be fined $500. And please see the probation officer. If you fail on probation, your probation could be revoked, then be found guilty and sentenced up to 1 year in the county jail. Anything else?
That's it, Judge.
Okay, that's all.
All right, let's go to Florida. Wade Mercer. We haven't been with him yet this week, so let's say good morning to him.
In the courtroom, we have our prosecutor. I want to ask to introduce himself because I want to make sure that you can see and hear him.
Jake Mitchell on behalf of the state.
Thank you. Corporal, see and hear all of us okay at the jail?
Yes, Your Honor.
All right, so Mr. Cordova is here as an interpreter, and the first interpreter case is Luis Bautista. Mr. Cordova, good morning, sir. Would you please introduce yourself to Mr. Bautista and make sure that he can see and hear you?
Good morning, Your Honor. Yes. Buenos días, señor Luis Bautista. Yo soy el intérprete, Jonathan Córdoba. ¿Me puede oír bien?
Sí, señor.
Yes,
We
Your
also
Honor.
have Danny Cordova. I believe that's Mr. Cordova standing next to him. And Mr. Cordova, if you make sure Mr. Cordova can see and hear you also.
Y señor Dani Córdoba, ¿también me oye bien?
Sí, señor.
Okay, they both can hear well, Your Honor.
Thank you. So, gentlemen, I'm seeing you this morning because in addition to the bond previously set, you now have a hold from the United States Immigration Service.
Muy bien, señores, aparte de la fianza que se les va a poner, también tienen un orden de detención de inmigración.
So what that means is you have the right to post a bond, but if you do, you will be released to the Immigration Service. You will not be released into the public.
Lo que significa eso es que si llegan a pagar la fianza, no van a ser puestos en libertad al público, van a ser puestos en las manos de inmigración.
If you do not post the bond, you will deal with your local charges first and then deal with immigration if they still want you.
Si no llegan a pagar la fianza, primero van a darle atención a las acusaciones locales y después van a enfrentar a la inmigración si es que ellos todavía los están buscando.
And Mr. Mitchell, I think you just told me that there's a motion for pretrial detention filed in one of these two cases.
Bautista. We talked about filing one, but I don't know if they still are one since there's a immigration hold.
I'll wait for him to translate.
Y señor Mitchell, usted me dijo que estaban haciendo una petición para una detención de libertad previa al juicio. Es para el señor Bautista, pero ya no sabemos si eso va a suceder por el orden de detención de inmigración.
Mr. Mitchell.
Yes, Your Honor. Ms. Jeffcoat actually filed a motion for pretrial detention and was going to let the court know about it yesterday.
Sí, señor Mitchell, sí, la señora Jeffcoat hizo una petición para detención previa al juicio y iba a dejar saber a la corte ayer.
But we didn't see Mr. Batista yesterday, but still, as of right now, Ms. Jeffcoat is going to be in contact with Judge Garcia regarding that motion for pretrial detention.
Just let you know, Sherry
Entonces,
is talking.
ayer pues no vimos al señor Batista. Ayer, entonces la señora Jeffcoat se va a comunicar con la jueza García.
Mr. McDaniel, you were saying something.
Ms. Jeffcoat has already emailed Judge Garcia. Judge Garcia emailed her back and asked her if it changed her mind about needing a hearing for that, because he was being held without bond on the immigration. I have not heard back from Ms. Jeffcoat since then, though.
Entonces, señor McDaniel dice que la señora Jeffcoat se comunicó por correo electrónico con la jueza García y la jueza García con la señora Jeffcoat. No saben si iban a cambiar de parecer sobre ese asunto.
Okay, so let's see if anybody has any questions. Mr. Cordoba, any questions, sir?
Entonces vamos a ver si alguien tiene alguna pregunta. Señor Córdoba, ¿tiene alguna pregunta?
No, podría firmar una, ¿se llama eso?
Podría firmar una orden de
Una orden
deportation.
voluntaria de migración.
No, could I sign a document saying that I would like to voluntarily be deported?
Not while you have pending felony charges. The only way you could do that is if the state agreed to dismiss the charges, and that's not happening at this point.
No, mientras que usted tiene acusaciones de delitos graves pendientes, tendrían que deshacer las acusaciones, pero en este momento no van a hacer eso.
Wish you the best, sir.
Esperamos que tengan lo mejor.
Mr. Bautista, do you have any questions?
Señor Bautista, ¿usted tiene alguna pregunta?
Sí. ¿Hay
Yes.
alguna posibilidad de que nos trasladen a un centro de ICE?
Is there a possibility of they can take us to like a nice hold detention center?
The only way you will go to immigration is if you post your bonds here first.
La única forma que van a ir con inmigración es que si primero pagan su fianza aquí.
If you don't post the bonds here, you will deal with your criminal charges and then deal with immigration later.
Si no llegan a pagar su fianza, primero se van a enfrentar a las acusaciones de delitos graves aquí y después se enfrentan a la inmigración después.
You have any other questions?
¿Tiene alguna otra pregunta?
Thank you.
Have a good day, sir.
Buen día.
¿Será que me pueden dejar utilizar mi teléfono para llamar a alguien? Es que estoy incomunicado desde el día que me arrestaron. Y me dijeron que me iban a dejar comunicar, pero no me han dejado hacer nada.
Is it possible to be able to use the telephone? Because I haven't been able to use the phone since I've been arrested, and they told me that they were going to allow me to do that.
Yes, you have the right to use the phone anytime your bond situation changes. Since you've been made aware of this immigration hold, you do have the right to contact friends or family and tell them what's going on.
Sí, usted tiene derecho a usar el teléfono siempre cuando el asunto de fianza cambia. Usted sí puede usar el teléfono.
Corporal Jones, don't let him do that after first appearance. I appreciate it.
Yes, Your Honor.
Puedo sacar el número de mi teléfono personal. Es que no recuerdo para llamar a alguien.
Would I be able to look for the phone numbers in my cell phone? Because I don't remember anyone's phone numbers right now.
I can't answer that question. I don't know if your phone was taken into evidence or not. I have no idea. Some of the phones in these cases were subject to search warrants. I don't know about yours.
No pudiera contestar esa pregunta en este momento porque a veces si les quitan el teléfono por pruebas, entonces puede ser que lo detienen y entonces no se sabe ahorita.
Pero
if your phone is at the jail, typically they will let you use your phone to access phone numbers.
Pero si su teléfono está ahí en la cárcel, regularmente les permiten usar el teléfono para buscar los números telefónicos.
But if your
Sí,
phone was
es
taken
que-
as evidence, let me finish. If your phone was taken as evidence, they don't even have it at the jail.
Pero si les quitaron el teléfono por tener pruebas, entonces regularmente ni tienen su teléfono ahí en la cárcel.
Any
me
other
dijeron
questions?
que sí.
¿Alguna
Es
otra
que
pregunta?
tengo un perrito encerrado desde el domingo y no sé qué pasará. Ahí en mi casa y está solo.
I also have a little puppy in my apartment since Sunday, and he's there alone, and I don't know what's going to happen.
You may want to contact friends or family about that. There's nothing I can tell you about that, sir.
Quizás puedes comunicarte con amistades o familia sobre eso, porque no sé qué más decirle de eso.
Pero no recuerdo el número de teléfono, entonces necesitaría sacar el número del teléfono personal.
But I don't remember any telephone numbers, so I would have to look for the phone numbers on the phone.
That doesn't change my answer to your questions at all. Have a good day, sir.
Eso no cambia las respuestas a sus preguntas que ya le he dado. Ten buen día, señor.
We have Brandy Tyus next.
Is that all, Your Honor?
Ms. Tyus, good morning. Thank you, Mr. Cordova.
Okay, thanks. Have a good day.
You too, sir. Ms. Tyus, good morning, ma'am. You were held 7 days to see what happened with your Calhoun County violation of probation charge, ma'am, and they do have a no bond warrant signed by Judge Young on the 5th. So last Friday, Judge Young signed a no bond warrant. So when you get through with your Jackson County case, be aware that you do have a no bond warrant out of Calhoun. Your sister and another young lady are in the courtroom this morning. Ms. Tyus, I believe I got a text. I know we got a text from Mr. McDaniel saying that you may want to resolve your local charges. So I'm going to ask that you listen to your attorney.
Your Honor, I've spoken to Ms. Tyson, 25462 CT. She's going to enter a plea of no contest to the charges listed. The understanding she'll be sentenced to 60 days in the county jail. She'll have 9 days jail credit. There'll be a $400 fine, which would be a civil judgment if she don't work out while she's here at the jail. And she has signed a plea waiver form waiving the right to jury trial and call witnesses.
Thank you, Mr. McDaniel. Ms. Tice, did you hear that agreement, ma'am?
Yes, sir.
Ms. Tice, do you have any questions about that agreement?
Yes, sir.
And ma'am, is that the plea you would like to enter to resolve that new case?
I don't really have much of an option.
Yes or no?
Yes.
You do have an option, ma'am. Your option is not plea and contest that charge, and you'll be held on the VOP, and you have a bond already set in a new case. So you can't say you don't have an option because you do. If you want to resolve it, you can. If you don't, that's okay too. You want to resolve it or not?
I do.
Okay. And Mr. McDaniel, do you want that standard language that you normally ask for about the plea not being used against them in the VOP?
Yes, Your Honor.
And Mr. Mitchell, is this agreeable with the state?
It is, Your Honor.
Ms. Tyson will accept your plea of no contest to the charge of driving while license suspended or revoked knowingly in the Jackson County case. I'm going to judge you guilty of that offense. I'm going to sentence you to 60 days in jail, but you have credit for 9 days that you've already served. Ms. Tyson, I'm going to impose a standard court costs and fines of $400, ma'am. Those will become a civil judgment if you don't get them worked off. Hopefully you get them worked off at the jail. As you already know, you've got a hold in the VOSP out of Calhoun. As part of this plea agreement, I don't need to add this to the disposition. The plea itself cannot be used against you to violate your probation, ma'am. Mr. McDaniel does that to try to protect his clients. So they can still use the incident, but they can't use the plea, what you're doing today. If the state tried to use this plea, I'm putting on the record, I will let you withdraw this plea. I've never had them try to use it after we put that on the record, ma'am. So if they want to use this to violate your probation, they have to call witnesses from the original incident, not just use what happened today in court. Your plea can't be used against you, but they still can use the incident. So Ms. Tyson, when you get near the completion of your sentence, when she gets, I'm talking to your sister now, well, usually what happens if she gets down around a week or so, they're going to go ahead and contact Calhoun County and say, can y'all come get her? Because she's got a no bond hold. So she may actually do the last few days of her sentence in Calhoun County, which is actually to her benefit to get down there so she can deal with the charges against her there. Okay. Ma'am, in the courtroom, do you have any questions?
No, sir. I think I pretty much understand everything.
Okay. Thank you for coming. Ms. Tice, do you have any questions, ma'am?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
Yes, ma'am. That was 60 days done. That takes care of everybody we have in the courtroom, Mr. McDaniel. So let's go back to the top of the list, and that would be Brian Taylor. And Mr. Taylor. Good morning, Mr. Taylor. You're here because you've been accused of violating the terms of your state probation. Mr. Taylor, I've got a copy of the warrant in front of me, signed by Judge Garcia, our circuit judge, and it has no bond on it. Mr. Taylor, what that means is you're going to be held with no bond until you can get over to circuit court and get this allegation against you resolved. I'm going to go ahead and get you arraigned this morning. The reason I want to do that is because I want to get you a lawyer appointed if you're asking for one. Would you like to have an attorney appointed to represent you, Mr. Taylor?
Yes, Your Honor.
I'm going to appoint the public defender's officer to represent you. Listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor, we're going to plead not guilty. As set this on October 9th, pre-trial docket, and I advise you, Mr. Green, to come by and talk to him prior to that hearing.
October 9th. Mr. Mitchell, anything?
No, Your Honor.
Thank you. And Mr. Taylor, October 9th will be your court date. Do you have any questions, sir?
No, sir, Your Honor.
All right, sir. Wish you the best. Next, we have Jesse Taylor.
Yes, sir.
Mr. Taylor, good morning. Mr. Taylor, you're here for, you've been accused of one count of battery, domestic violence. Mr. Taylor, I've read the complaint in your case. There is probable cause. I've also looked at your criminal history, so I'm familiar with your criminal history. It's not, I wouldn't say it was little. I would say there's not a huge amount of stuff there. The most concerning thing is about a 3-year-old battery on a different female from a few years ago. But I think you're entitled to a bond as far as I can tell. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Nothing else, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Taylor, I'm going to set you the normal bond I would set for a battery, and that's $2,500 cash or surety. Cash or surety means you do not have to come up with all the money. Mr. Taylor, you can go through what it is. So after first appearance, you get to use the phone. You post that $2,500 bond, you'll be released. If you don't post the bond, then we'll see you on an upcoming docket. And I'm going to ask the jail to give you a notice for that docket in case you post the bond. And when would that be done? September 29th will be your court date. Mr. Taylor, September 29th at 9 a.m. At 9 a.m. But you will get to use the phone in just a few minutes, sir, to try to post the bond. Now, you need to understand that court date is if you post bond. If you're not able to post bond, we'll see you on a jail day. But I'm going to assume and hope you can post bond. And if you do, we'll see you September 29th. You will not get a notice in the mail. That notice they put in your hand will be the only notice you get. Any questions, sir? You do have a condition of no contact with alleged victim. Just be clear about that. I may not have said that. Any questions?
No, sir.
All right, sir. Wish you the best.
Yes, sir. Thank you.
2,500. Mr. McDaniel, that takes care of everybody on my first appearance list. So let's go to our, well, it's actually a little, well, these are for, it's for 9 or 8:45. We don't have any friends or family here. We may have some friends or family come in, and if we do, we'll cross that bridge if that happens on our jail arraignment and pre-trial docket. And Mr. McDaniel, which docket do you want to go forward first, the pre-trials or the arraignments?
Arraignments, I got Demetrius Batson.
Okay, this is the state of Florida versus Demetrius Batson, 25-387 MM, charged with one count of battery. Mr. Batson, good morning, sir. I'm going to appoint the public defender's officer to represent you in this case, Mr. Batson, and I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, we're just going to plead not guilty. I set this on October 8th with a trial date of October 20th.
10-8 and 10-20. Mr. Mitchell, anything from the state?
Not this time, Your Honor.
Okay, Mr. Batson, you have a question?
Yes, Your Honor. I have a problem with what's going on because I never received an information or indictment in 40 days of being incarcerated in this jail. So I was supposed to be released upon my own recognizance on the 41st day. So I want to apply for insufficient counsel because I spoke to Mr. McDaniel about it yesterday, and he's my lawyer, and he says a motion is supposed to be filed to receive that. Well, my lawyer is supposed to do that by the law, by the Florida law. If I'm not indicted or receive the information in 40 days, then I'm supposed to be released. I've been in jail over 40 days. I never received the information or indictment.
What the case law says, it's not self-executing. What that means is that it's the defendant's responsibility to file that and request that. You were not appointed a lawyer until today. Mr. McDaniel can't do anything until he's appointed to represent you, which just happened literally 30 seconds ago. Let me see what Mr. Mitchell's response is. Let me see what Mr. Mitchell's response is on the information, and we'll see where we're going from there. Mr. Mitchell?
Your Honor, his bond was revoked in his felony case because of this new charge right here. I was in discussion with Mr. Gill yesterday with Ms. Simpson, who represents him in the felony case, and Mr. McDaniel. he's being brought back up Tuesday on the felony case, and there's a potential possibility that they may resolve that case then, which in turn would resolve this case. So that's just where we stand for right now.
What is your position on filing the information, and what's your understanding of the timeline that you have to file it within?
I mean, if he doesn't resolve it on Tuesday, I'll file an information afterwards.
Under the new rule, you have 60 days. Is that right?
Yes.
Yeah.
Yes. And he's been in custody for 52 days.
So Mr. Batson, the new rule started July 1st. They have 60 days to file that information. My understanding of the rule is it's a brand new rule, rule of procedure. That is, if they don't file it within 60 days, and if you file a motion, then you're entitled to be released unless they file information by the 63rd day. So right now, it appears to me they're in compliance with that rule. And as you said, you've got court next Tuesday.
Yes.
On the felony charge.
When is that? The 16th? Yeah, the 16th.
But the public defender's office is now appointed to represent you. Do you have any other questions?
Yes, I have a question because you're saying that it says 60 days, but the video you played this morning says 40 days. So
Yeah,
I'm not understanding. I'm not understanding what's going on.
Okay, that's a fair question. That video is out of date. This rule just took effect July 1st. We've started the process of getting a new video recorded. It just hasn't got completed yet. I expect that video to be finished this week. It's just not been done yet. Any other questions? All right, wish you the best, sir. We have Cody Biller next.
Always
Get him back up there. 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 Billy, you step to the side.
Question.
Mr. Batson, you know, as many times you've been in front of me, you know, I'm not going to tolerate that kind of language in court. You can apologize and I'll forget about the whole thing, or we can have a contempt hearing. Which would you rather do?
I apologize.
Have a good day, sir. Cody Biller. Mr. Biller, good morning. You're here for first appearance accused of one count of trespass in case 25-443 MM. Mr. Biller, in that case, I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney, Mr. McDaniel.
Your Honor, we're going to plead not guilty. Yes, set this on October 8th, pretrial, trial date October 20th.
October 8th, October 20th, Mr. Mitchell.
No objection to that.
Mr. Biller, any questions?
No, sir.
All right, sir. Wish you the best. We'll see you October 8th. We have Anthony Godwin next. Mr. Godwin, good morning. Mr. Godwin, you're here for first appearance, sir. You've been accused of one count of affray and one count of disorderly conduct. Mr. Godwin, I'm going to appoint the public defender's officer to represent you, sir, and I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Godwin in 25-396 MM. He's going to plead no contest to the charges as listed. Understanding he'll be sentenced to 60 days in county jail. You have 52 days jail credit, be a $370 fine, which will be a civil judgment. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. I think I did also discuss that I would dismiss the charge of affray, so he would just be pleading to the second degree misdemeanor of disorderly conduct. I mean, I'm fine with that also.
Mr. McDaniel, you okay with that?
Yeah, I meant to say that. I apologize. Yes, Your Honor.
Okay.
So, Mr. Godwin, if you enter this plea, you're only pleading to one count of disorderly conduct, and the plea agreement is what Mr. McDaniel said. Any questions about that?
Number one, I'm unable to pay any court fee because of the reason I'm homeless and I'm fixing up my house. I don't have no job at the time or any income.
You say you're homeless and you're fixing up your house? Is that what you said?
Yes.
How are you both homeless? How are you both homeless and fixing up your house?
Well, my house is it was tore up by the hurricane, and I'm living in a hotel.
So the house is not livable, is what you're saying, right?
Yes.
Okay. So here's what you need to understand: that the plea, paying the fine has nothing to do with you getting out of jail. You finish the sentence, you'll be released. You also will get a chance to work off the court costs and fines at the jail if you take this plea. If you don't get them worked off, then what happens is your driver's license may be suspended, and there'll be a civil judgment against you. Knowing all of that, you still want to enter this plea?
I don't have no driver's license.
Answer is yes.
Okay. Do you want to enter this plea knowing all of that, though?
Yes.
Mr. Godwin, I'm going to accept your plea of no contest to one charge, and that charge is the disorderly conduct. The affray is being dismissed by the state. I'm judging guilty of that misdemeanor offense. I'm sentencing you to 60 days in jail. But Mr. Godwin, you have credit for 52 days you've already served. That means you have at most 8 days left. 370 court costs and fines. That'll be reduced to a civil judgment if it's not worked off at the jail. And Mr. Godwin, there's no probation involved in this sentence, which means you finish the 8 days. Sir, you'll be released and this case is over with. These cases are over with. Mr. Godwin, do you have any questions?
So after I finish the time the case is over with, the ended it of the case.
I didn't understand your question. Can you ask that again?
Okay. The question I wanted to know, my life management lawyer was supposed to be here to represent me as well because of my incompetence in things and my mental disorder. And she was supposed to be here also. Why wasn't she here?
I have never seen life management attorney have an attorney representing someone that they don't represent you. I've never seen an attorney for them. I've seen. Let me answer your question. I've never seen I've seen a counselor show up before, but I don't know if life management has an attorney. The question is, do you want to enter this plea? Do you feel like this is what you want to do or not?
Yes, I want to do that.
Okay.
My counselor.
Well, your counselor is not your legal advisor. Your attorney that's been appointed to represent you is right next to you, and I'm accepting the plea. I wish you the best, sir.
Yeah. All right. Good luck to you.
Have a good day. After Mr. Godwin, we have Travis Hayes.
Your Honor, I'd like to go ahead and enter a plea in the absence of Mr. Hayes. Said it not guilty. Asked to set it on October 8th, pre-trial docket, just on the 8th. No need to get on trial docket. He's supposed to try to, life manager supposed to try to see me in the day, and we'll see if they have any success with it.
Okay, so what I'm going to do, Mr. McNally, I've got to get y'all appointed. So I'm going to tentatively appoint y'all. Go ahead and appoint y'all to represent him. If you find out he doesn't qualify for some reason, or if he doesn't want your appointment, we'll cross that bridge. But I need to get him an attorney appointed for now. And October 8th, you say, Mr. McDaniel?
Yes, Your Honor.
Perfect. Mr. Mitchell, anything on Mr. Hayes?
So that's just for the pretrial. He's not set for the trial.
He's not even competent. I don't even know how I can try.
Yeah. Yeah.
See
No
what
objection.
Okay. Next, we have William Eric Jackson, case 25-434 CT. Mr. Jackson, good morning. You're here because you've been accused of one count of driving under the influence and one count of leaving the scene with property damage. Mr. Jackson, I am appointing the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Jackson in case number 25-434 CT. He's going to enter a plea of no contest to the charge of the DUI. The state's going to dismiss the leaving the scene of an accident. It'll be 11 months, 29 days probation, $1,603 in fines, 100 hours of community service work, DUI, school, and counseling as directed by the state, and the minimum driver's license suspension. He has signed his waiver, waiving his right to a jury trial, and called witnesses. And this resolved his case.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor, and no information had already been filed for the leaving the scene of an accident because the court found no probable cause at first appearance for that. So I did file an information just for an enhanced DUI. So that's what he's pleading to.
Thank you. Mr. McDaniel, I couldn't hear you. Say again, please.
Correct. We are pleading to the enhanced DUI that he filed.
So I don't have any first appearance notes because of the no probable cause. It looks like I wanted to give the state time to take a look at everything. So I don't know anything about his prior driving history. Does he have a prior DUI?
From what I could find, I did not see any prior DUIs. Let me look again. He did have one 25 years ago.
That's not going to affect what I would do. Okay. Mr. Jackson, did you hear that plea agreement, sir?
Yes, sir. Jake, would you
Mr.
have
Jackson.
any suggestion to lower that fine to the first degree? It saved him a lot of money. I just, fine. It's been 25 years. I didn't realize that long ago.
Yeah, the fine was mainly based on what his BAC was, considering I filed as a enhanced, but I have no objection to lowering it to the minimum fine if that's agreeable with the court.
I don't have a problem with that either, but you say he's pleading to what he's charged with. Is what he's charged with, is that
It's enhanced, yes.
but what do you mean by enhanced? DUI can be enhanced several ways. He's pleading to over 0.15.
Yes.
So over 0.15, does that change? That's a different fine than second offense.
Oh, okay.
Okay, so it's over 0.15 fine, right? So Mr. Jackson, if you enter this plea, the fine is $1,603 because it's over 0.15 fine, not because it's a second offense fine. Mr. Jackson, knowing that, do you have any questions about the plea agreement, and is that still what you want to do?
Yes, sir.
Mr. And that was a horrible question I just asked, because I asked you 2 questions at one time. You do not have any questions, correct?
No, sir.
But you do want to enter the plea, correct?
Yes, sir.
I'm going to accept your plea of no contest to the charge of driving under the influence of over 0.15 breath or blood alcohol in case 25-434 CT. The judge is guilty of that offense, sentence you to 11 months and 29 days probation. Mr. Jackson, you'll have the standard conditions of probation. In addition to the standard conditions, you'll pay court costs and fines of $1,603, successfully complete substance abuse counseling, 50 hours of public service work, and DUI school. I do recommend the minimum driver's license suspension. You're going to add something else?
That's enhanced.
Is it 100?
It's 100, yes.
Is that because of it's over 0.15? It's 100 hours?
Yes.
I didn't even know that.
I followed the plea schedule that I was given on that, and that's what it said right there. So,
Okay.
because I had to look it up myself.
The plea schedule from the statute? Or are you talking about plea schedule?
Yes, plea schedule from statute.
So, Mr. Mac, did he announce 100? Mr. McDaniel announced 100? Okay. Sounds like everybody's on the same page then. Mr. Jackson, there's a possibility of getting on probation early. In order to do that, you got to do half the probation, have no violations. Mr. Jackson, what's going to happen next is they're going to bring you to the courthouse, because that's where the probation office is at. They'll let you get dressed. They'll let you use the phone. Then they'll bring you to the courthouse. When you get here, you'll meet with Mr. Goodson, the probation officer. Mr. Goodson will go over the probation with you and give you a chance to ask any questions, and then you'll be free to leave. Mr. Jackson, if you do contact friends or family, you can tell them that you can be picked up at the courthouse, probably 30 to 45 minutes. It's when you'll be free to be picked up from the courthouse, not from the jail or from the courthouse. He had no civil infractions, did he? Mr. Jackson, that resolves your criminal case. They also wrote you a speeding citation. Let me take a look at that. What'd you say, Dawn? Speed too fast for conditions. Mr. Jackson, give me a second to see what that specifically they've accused you of. I know what I'm probably inclined to do, but I want to check the speed just to make sure it's not 100 miles an hour. You've also been accused in 25-2473 of speeding too fast for conditions, and it looks like a citation doesn't even have a speed on it. They just said that it was raining and you allegedly were going too fast for that specific road condition, and that's when this trooper issued the citation. So, Mr. Jackson, if you wish to plead, if you want to contest this, you can. If you want to plead to it, plead no contest to this speeding citation, I'm going to waive the court costs and waive the fines, waive the points. Because you've already got plenty big enough fine in the DUI, I don't see a whole lot to be accomplished by adding additional fine because of this speeding. So if you'd like to plead no contest on the speeding ticket, I'm going to waive the points and waive the fine. You also have the right to contest it. You want to resolve it today and plead no contest to that if I waive the points and waive the fine?
Yes, sir.
Did he say yes?
He said yes.
Yes,
Okay.
yes.
So I'm going to show a plea of no contest to speeding too fast for conditions, withhold the points, waive the fine. That one's over with. You've got the other fine imposed. Mr. Goodson has a question. Mr. Goodson. I don't, was it over 0.20?
Yeah, it was 0.3.
So anytime there's a breathalyzer of over 0.20, then I double the counseling on any sentence. So you'll have twice the counseling. Now that means if you choose to go to AA, you go to 24 instead of 12. Also, Mr. McDaniel's probably told you that if you do go to the DUI school within the first, if you, okay, we don't do them in a second. So if you go to DUI school, you may get credit for some counseling towards that DUI school. If you don't enroll in the DUI school within the first 60 days of being on probation, then you can just go to counseling as you wish to a private counselor or to AA. Mr. Jackson, everything else I told you about coming to the courthouse will happen in the next 30 to 45 minutes. Any questions, sir?
No, sir.
All right, sir. I wish you the best.
Thank you.
Yes, sir. We have Roy Charles Pepples next. Peoples. Good morning, sir. You're here for first appearance, or actually for arraignment, because you've been accused of one count of battery. I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, we just enter plea not guilty. Asked to set this on October 8th, pretrial, trial date October 20th.
October 8th and October 20th. And Mr. Mitchell?
No objection to that.
The offer in this case is time served. So
Yes, Your Honor. He has 2 pending felony cases, and his bond has been revoked in those 2 cases because of this charge right here. So,
all right, so we're going to see October 8th with a tentative trial date of October 20th. Any questions, sir?
No, sir.
All right, have a good day. Emmanuel Yisrael, page 24-417 MM.
got it pretty good on that attempt, I think.
Mr. Yisrael, good morning. You're here because you've been accused of one count of battery. Sir, I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney, Mr. McDaniel.
Your Honor, we're going to enter plea of not guilty. Asked to set this on October 8th, pretrial, October 20th, trial date.
Mr. Mitchell?
No objection.
Mr. Yisrael, October 8th and October 20th. Any questions, sir?
He's shaking his head no.
No questions? All right, have a good day, sir.
See you soon.
Next case we have is, that's it for our arraignment docket. We only have 2 cases on the pretrial docket. The first one of those is Cleveland Dixon. Mr. Dixon, come on up. Mr. Dixon, good morning. You're here in case 25-379 MM. This is a trespass charge. You've already been arraigned on. Listen to Mr. McDaniel, Mr. Dixon. We'll see where we stand in this case.
Your Honor, I was talking to Mr. Dixon. We're just going to go ahead and leave it on the trial date for September 22nd. And, unless something changes, we'll be ready for trial.
Mr. Mitchell.
No objection to that. We can set it on the trial date.
September 22nd. Mr. Dixon, any questions?
No, sir.
All right, sir. We'll see you on September 22nd at 9 a.m. unless we see you before then.
I will go ahead and put out, we don't need him up here. I will go ahead and say our office is closed on the 23rd. So if we set jury selection for the 22nd, we may just have to do the trial on the 24th.
We'll figure out a date that week sometime.
Okay.
Mr. Howard is next. State versus Bradley Howard, 25-380 MM. Mr. Howard, you're here on your battery charge. I've already appointed the public defender's office to represent you. Mr. Howard, listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Howard. He's going to enter plea of no contest in 25-380 MM with the understanding he's adjudicated guilty, 60 days in the county jail, 57 days jail credit, $722 fine, which would be a civil judgment. And I think clerk's office gives him 60 days to pay that, or he'll end up getting his license suspended. He has signed his plea waiver form, waiver trial, jury trial, and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. And I did just want to throw in a little bit of information for Mr. Howard also. John's okay with that.
Yeah, the November court date in
Gadsden County.
Yes, sir.
Okay,
I do know
so he
about
is
it.
aware. He knows to
Yes,
make an
sir.
appointment with his PD. I did
Yes, sir.
also want to put out there that there is an injunction that has been issued against Mr. Howard from the victim in this case. So
Yes, sir.
Mr. Howard cannot go within 500 feet of him or his residence.
Yes, sir.
Stay away from
Yes,
him.
sir.
Get to Gadsden County.
Yes, sir.
Mr. Howard, as far as the case that you're on here today for, did you hear that plea agreement, sir?
Yes, sir.
Do you have any questions about that agreement?
Do I get any jail credit for the days that I've been here?
Yes, sir. You have credit for 58 days. So you only have 2 days left. It's 58 or 57?
I got.
Okay, so the disposition
58.
says 57. Mr. Mitchell's offer says 58. So which is correct, Mr. McDaniel?
I mean, I want to say mine's correct, but I'll go with it. I don't mind going with 58.
Give me a second. I'll double check.
I don't know that anybody here really cares other than Mr. Howard. So, Mr. Mitchell, you okay with 58 days credit?
I am fine with 58 days.
Mr. Howard, if you enter this plea, you're going to get 58 days credit if Mr. State's okay with it. I mean, it's a number on a piece of paper to me, but to you, it's a day of your life. So I have no problem with that if that's what you want to do. Is that what you want to do, sir?
Yes, sir, 58.
And is that the plea you would like to enter?
Yes, sir.
Mr. Howard, I'm going to accept your plea of no contest in case 25-380 to the charge of battery. Sir, I'm going to judge you guilty of that offense. I'm going to sentence you to 60 days in jail, give you credit for 58 days that you've already served as agreed to by the state. $722 court costs and fines. That'll be reduced to a civil judgment. Mr. Howard, you have 2 days left. Mr. Howard, and keep in mind whatever instructions you were given about Gadsden County and the
Yes, sir.
injunction. Have you been served with that injunction, sir?
Yes, sir. I don't have it in my possession, but yes, I do know about it. And I'm sure that when they release me, that it will be in my paperwork.
Okay, fair enough. Do you have any questions, Mr. Howard?
No, sir.
Our clerk has one thing. Yes, ma'am. Mr. Howard, under Florida law, is it 90 days?
Actually, it's 30 days.
So under Florida law, they have to suspend licenses for unpaid fines after 30 days. But you can avoid that by coming to the clerk's office and setting up a payment plan. They can take that fine and spread it out over a year. Is that right, Don?
Yes, sir.
And as long as you make those payments, your driver's license will not be suspended. If you don't do that, you understand your license very well may be suspended. In fact, it will be suspended if you don't make arrangements to get up on a payment plan or pay the fine in full. Just be aware of that. Okay.
Okay, yes, sir.
Wish you the best,
Understood.
sir.
Thank you, sir.
Yes, sir. All right. So, Mr. McDaniel, that's everything I had on my list for first appearances, arraignments, and pretrials. Anything else I may have missed, sir?
I don't have anything else, Your Honor.
Corporal Drown, anything else from the jail?
All right, that was a pretty big docket from Mercer, bigger than he normally has, but we haven't seen him in a couple of days, so we squeezed it all into one. Let's go back to Judge Stevens in Texas.
There is a motion to revoke probation that's just been sitting around, right?
No, we had no.
You should read it through.
Okay.
And, okay, because these were not substantive violations, like the court, it's community service and failing to report, the court held any further action in abeyance. And so she's been on probation since 2023 for injury, a state jail felony, injury to a child. And then from probation, how are we doing?
Your Honor, she reports as directed. We're still not where we'd like to be as far as payments are concerned. Ms. Handy has not made a payment since April of 25.
Payments, this is going to be payments for what?
Payments towards her supervision fees and court order fees.
Why not?
I haven't enough money to pay.
Okay. Without money.
No, I pay my bills, like my bills.
Well, this could put you in jail if you don't.
Yes, I understand.
So what are we doing about it? Are you working somewhere?
Yes, sir.
Where do you work?
Harmony Care.
And so how much, what's your income there?
I make $16.50 an hour.
Okay, so that's about a little over 35, between 35 and 40. So is there any other income in the household?
No, sir. I've been paying.
You're the only income earner in the household?
Yes, sir.
And the child, you have a child there, right?
Yes, sir.
Okay.
Yes, sir.
How many?
Altogether, I have 4 children.
4 children. Hold on. The fathers of the children are responsible, or maybe they're irresponsible, but they're supposed to be paying if they have to pay fair support toward a responsibility they brought into the world, like being a father. But I know a lot of people aren't like that, irresponsible, but you have 4 children. How many fathers?
2.
2. And they're not helping you at all? Have you talked to him about that?
Yes, sir.
Because I think he might be able to help you legally. Are they working somewhere? Do you know? They work, or are they bums?
Pretty much bums.
Pretty much bums. No, it's just, what happens is somebody pays for all of this.
Yeah.
And it's going to be the taxpayers for everybody's responsibilities that are neglected or completely betrayed. And All too often that happens in this courtroom. So what do we do?
Our position today, Your Honor, is this is just as part of it, just a status check that she's doing.
I know.
Maybe not as great as she's supposed to do.
The right thing done.
But she's checking in, she's doing.
I understand.
I would say, can you continue on probation and check to see if she's.
Well, we're going to continue on with probation. I'm just, the costs that are being endured by the taxpayers frustrate me and frustrate them. And they want to know, what are you going to do about it, John? But there's been, you haven't talked to anybody about holding them legally accountable and
I can let her talk with the bar association and see if they can find a family lawyer. I mean, I don't.
Because you're not supposed to burden, and the taxpayers like me aren't supposed to be burdened over your responsibilities, but they have responsibilities too, that they're neglecting and making you pay the way.
I'll be out before today and see if I can get.
They may not care about being a father, but they have a legal responsibility that can be enforced. And that generally can be done through competent legal counsel.
Did I hear you say you were paying support yourself, man?
Yes.
You pay all it.
And is that pursuant to a court order?
This one? Yes. Is it this one?
Yes.
So the children you mentioned to the judge, are they in your care or somebody else's care? So you're actually legally obligated to pay child support for those children to the grandmother.
Well, can't talk about for one child.
The one child you're legally obligated to pay child support to. How much is that child support?
223 every 2 weeks.
So in addition to what the judge was talking about, you have your own legal obligation to pay for support for that child. Is the father paying child support in that as well or no? It's very problematic, Judge.
Yes.
But I did overhear her say that she's required to pay that court-ordered amount.
How many of the children are with you? The other three?
Yes.
Oh, okay. And those three, the fathers don't pay child support for those three. So are they supposed to? Is there a court order says they're supposed to?
I did go to court for one, but he did disability. That
That's where I guide her where she's talking about the three children, but she apparently owes child support herself. And even paying your child support, right? So
that still doesn't help the taxpayer.
No, we still asked, and there's still money owed here, but.
What's our next event here?
This was just a review.
Yeah, when do we want to do another review?
I say do a review down the road. I don't know.
3 weeks, 3 months?
Yeah.
Okay.
I'm not saying no to 3 weeks, but 3 months. That's good. Yeah, let's do that.
Okay. All right. Please get a resetting.
It's not agree with each other.
That's good. That's important.
She's not finished now. She's done 6 hours. It's 6 hours on 6.
I just went 2 days ago and got $200. I had 140 hours left.
I understand that there.
Has it been turned in yet or?
Well, no, they're not. They couldn't give out that many hours. She was ordered 6 hours. Right, so.
Just work with them and. Okay.
John, would you help her on that other thing?
When you get finished, wait for me outside. I'm gonna help you kind of go the right way. But possible that may help us.
Somebody, I don't know. I can't do it, and
I don't either.
I think you're the only one who can.
I know some was that if he wants to leeway, maybe they'll help.
Please get a reset. Correct, LaFleur.
So for.
Okay. Start there. Okay. Yeah.
Ms. LaFleur? Okay, DWI with Giles. What are we doing today?
Your Honor, me and Ms. Gaffney have been talking, if this is one of Sonny's old cases, me and Mr. Eckert were never able to come to a resolution. I think now that Ms. Gasper's on, we should be able to make some movement.
It's a year old.
Oh, I know.
No, it's, what are we doing?
Judge, I'm gonna need the medical records. I've already worked on starting to get them, but I don't have them at this time. There is an offer on the table. I have related to Mr. West, but we're not at an agreement at this moment.
She get the medical records and looked at may help us determine what to do. We have something. If we get a short resetting, like I said, it's a new case with her. If it was still Mr. Eckert, I'd say just put it on the trial docket, but I don't want to date yet. With Ms. Gasper, I want to let her try to see if we can work it through something.
Well, if we don't, then we start over from.
Well, I mean, if you want to put it on the trial docket and we can still agree, if you still let us work an agreement, we could do that.
Are you driving a motor vehicle?
No, Your Honor.
Because do you have a driver's license or was that suspended?
I have a driver's license, but it was suspended, but it's active now.
I think she went through a suspension, now it's back. She went through a suspension, she says active now.
But you're not operating a motor vehicle?
No, Your Honor.
I think it's pursuant to the law. She's not.
Okay, we're gonna just put it on the trial docket and try to.
It's fine. It's gonna go get it resolved, but if we don't do that, we can say that.
Okay, thank you.
Mm-hmm.
I have Damian Rawls.
Your Honor, I spoke to his family last week, and at that point, he was in custody in Harris County. That he was going to be transferred from there to, I believe Montgomery County. So he is currently in custody in another county. So, now this is what I've been told. I can't. I haven't.
You know, I don't have that on.
I think we pulled him, Judge, because he went to sleep. He's not here.
Say that again?
I think we pulled Mr. Wall's files because he's in jail, but elsewhere. He's not in our jail, so we couldn't get him.
I'm not sure what jail he's in right now, but he's in custody.
What do we do then? What do we do?
Just
Wait and see where he lands and try to get him over here.
Supposedly he was going to be getting credit time served in those locations, so he will be back out on and make it the next time. But he can make it today. So I'd say reset it for about 4 weeks and see where that
We just him being shipped between.
All right, well, they sort things out procedurally there. Let's go to Miami-Dade. We'll check in on Glazer as it's approaching lunchtime. So funny story, yesterday afternoon as I was working here in the studio, I had her afternoon docket on in the background, and there was a defendant that actually kind of called her out a little bit and told her that she needed to get outside more. Direct quote from him, "Judge, you need to get outside more." To her credit, she just kind of laughed it off and said, "Thanks a lot." But I did manage to capture that, so at some point that's going to be a short. Anyways, let's see what's going on.
Well, for pretrial? No. He's a signal. Tap alternate bond, $2,500, count 1 and count 2. Will be tap alternate bond, $2,500, count 1, $500, count 2. And you have an address, right?
Yes.
Yep, thank you. Make sure to keep all future court dates. Have a nice day. Next is Alfonso Hurtado. Page 14. Good morning, sir. You were arrested for possession of fentanyl, a controlled substance. I will appoint the public defender's office for you.
Requesting a bond based on criminal history. He was sentenced to 364 upon revocation of probation last year.
He also had a lot of fentanyl, over a gram, 1.2 grams.
Judge, that other case the state referred to was an arrest from October 2023, almost 2 years ago.
You have an address?
Yes, 765 East 6th Street.
Will pretrial take him?
He's also got a conviction for tampering with an electronic monitor.
Okay, tap alternate bond, $2,500. Make sure to keep all future court dates, sir. You know that fentanyl will kill you. You got to get drug counseling if you want to try and get any semblance back of a normal life. Good luck to you.
Tapped over state's objection.
So noted. It's not violent. Jose Calderon, page 14.
Spanish is preferred.
Good morning, sir. You were arrested for possession of a weapon by a convicted felon, possession of cocaine, and possession of drug paraphernalia.
Buenos días, señor. Usted fue arrestado por tenencia de un arma por parte de un delincuente condenado, tenencia de cocaína y tenencia de parafernalia para el uso de drogas.
So it's a pocket knife. One knife's a pocket knife. The other knife doesn't have a description.
Correct. I don't know if Ms. Corey wants to waive the issue.
Uno de las armas es una navaja y otro no tiene descripción. No sé si la abogada Corey quiere obviar este tema.
His felony convictions from over 20 years ago.
La condena que tiene es de hace más de 20 años.
It's an ordinary pocket knife. Why should she
Because we
waive
don't know the
issue?
description of the other one. The other one may qualify as a weapon.
So then set it for a probable cause hearing if it's violent, or we can give, or not, but we're not going to have her agree to that.
Bien, entonces no tenemos descripción de del segundo cuchillo, entonces lo que se puede hacer es fijarlo para audiencia para verificar motivos fundados, porque no es, si no, entonces no sería un delito violento.
You can reset it.
Okay. All right,
I didn't
reset
know
it.
That's-
Reset it
we're
for the
resetting it for
afternoon.
probable
Yeah.
cause?
Yeah, reset for probable cause hearing.
Para por la tarde queda fijada la audiencia para ver si existe motivo fundado.
Next is Ariel Leva. Page 14.
Spanish, please, Spanish.
Top of page 15. Good morning, sir. You were arrested for criminal mischief over $1,000.
Buenos días, señor. Usted fue arrestado por daños a la propiedad o fechoría por más de $1,000.
I will appoint the public defender's office for you.
Voy a asignarle a los abogados de oficio para que lo representen.
Then he's out on probation. There's a hold for case F24-15512.
Había salido bajo fianza, tenía libertad condicional. Hay una detención por el caso F24-15512.
Sir, you were ordered to stay away from the Orion gas station at 898 Palm Avenue in Hialeah, Florida.
Señor, usted se le da la orden de mantenerse alejado de la gasolinera Orion que queda en la 898 Palm Avenue en Hialeah.
You're not allowed to go to that location. You must stay away from there.
Usted no tiene permitido ir a este lugar, tiene que mantenerse alejado.
So he was carrying a black bag with heavy items in there, and he swung it at the window, and it caused the window to crack, damages approximately $1,000.
Entonces él tenía una bolsa con artículos pesados dentro de esa bolsa negra, la lanzó hacia la ventana y la quebró, y los daños se calcula que son aproximadamente de $1,000.
So I'm setting your bond at $1,000. There's probable cause for the charge.
Si existe motivo fundado por el cargo, estoy fijándole la fianza en $1,000.
Next we have is Brandon.
Your Honor,
What?
you have him on probation.
Yeah, as a hold for Judge Young for his open probation case. I said it. I
Tiene
thought I said-
detención por lo que tiene un caso abierto ante el juez Young.
F25-15512. No, that's not him. So yeah, it is him, sorry. Brandon Mendez Mendoza. I'm sorry, Brandon Mendoza, page, what are we on, 15, King Save. Good morning, sir. Do you speak English?
Spanish, please.
Sir, good morning. You were arrested for 2 cases, possession of cocaine and possession of drug paraphernalia.
Buenos días, señor. Usted fue arrestado por 2 casos. Un caso es tenencia de cocaína, el otro es tenencia de parafernalia para el uso de drogas.
The other case is burglary to an occupied structure and tampering with physical evidence.
El otro caso es allanamiento con fines delictivos a una estructura ocupada y manipular pruebas físicas.
So I will appoint the public defender's office for you.
Voy a asignarle a los abogados de oficio para que lo representen.
So for the possession of cocaine charge, he has a pipe with cocaine residue, so there's probable cause.
Por el cargo de tenencia de cocaína, tiene una pipa con residuos de cocaína, o sea que sí existe motivo fundado.
So it's $1,000 bond count 1 and 500 count 2 for that case.
Por ese caso es $1,000 de fianza por el cargo número 1, 500 por el cargo número 2.
So the other case, it looks like he fell from the roof inside of the Truist Bank over in Miami on Northwest 12th Avenue.
Y por el siguiente caso, aparentemente se cayó del techo del banco Truist en la 12 Avenida del Noroeste de Miami.
The person inside the bank was cleaning, and then while he was inside, he said an unknown male fell from the roof of the bank.
Había una persona dentro del banco limpiando y dijo que en ese momento una persona desconocida cayó del techo del banco
And so he ran out of the bank because I guess he got scared.
y aparentemente se asustó y salió corriendo del banco.
So the police and the canine searched the bank. No one was located.
La policía junto con los perros de la policía buscaron en el banco y no encontraron a nadie.
There was damage observed to the right and front left portions of the ceiling.
Se observaron daños a la parte derecha y del lado del frente del techo.
And they got surveillance video, and it showed at 16:49 hours, a subject emerged from the bushes.
Tenían cámaras de vigilancia y se observó que a las 6:49 se observó a una persona salir de los arbustos
Onto the camera.
y aparece en la cámara.
He entered the branch through an unlocked door.
Entró a la sede por una puerta que estaba sin llave.
He's seen running down the hall of the bank near the vault.
Y se ve que está corriendo por el pasillo del banco cerca a la bóveda.
He's inside the ATM vault room where he lingered and stood around and tried to manipulate the equipment.
Y estaba al lado de la caja fuerte, la bóveda de la máquina del ATM, de sacar dinero, y ahí estuvo manipulando el equipo.
And then he climbed on top of the ATM or vault and entered the ceiling.
Y luego se subió encima del cajero automático o la bóveda y llegó al cielo raso.
Then he's seen dropping down from the ceiling, and then it showed him fleeing from the branch.
Y luego se ve en las cámaras que cae del cielo raso y sale corriendo de la sede.
And the officer was able to identify Mr. Mendoza as the person who broke into the bank.
Y luego el agente de la policía pudo identificar al señor Mendoza como la persona que se entró al banco.
And the witness positively identified him, so there's probable cause for the burglary charge. I'm not sure what the tampering with evidence is.
I think they
Y,
said he was
y luego el testigo pudo identificar al señor, entonces sí existe motivo fundado por el allanamiento con fines delictivos. No estoy segura del otro cargo.
He moved the camera. He moved the camera by the ATM.
Allá, movió la cámara que estaba al lado de la máquina de retirar dinero.
So, sir, you are ordered to stay away from the Truist Bank at 100 Northwest 12th Avenue in Miami, Florida.
Entonces, señor, se le da la orden de mantenerse alejado del banco Truist que queda en la 100 Northwest 12 Avenida en Miami.
You're not allowed to go to that bank, and you must stay away from there, sir.
A usted no se le permite ir a ese banco y tiene que mantenerse alejado.
Count 1, burglary to the occupied structure will be $10,000.
Cargo número 1, allanamiento con fines delictivos a la estructura ocupada, será de $10,000 la fianza.
And count 2, tampering with physical evidence is $2,500.
Y manipulación de pruebas físicas, la fianza es de $2,500.
Have a nice
Mr.
day.
Mendoza does not have funds for a bond. Would your honor consider house arrest as an alternate?
Su señoría, el señor Mendoza no tiene fondos para una fianza. ¿Se podría tomar en consideración arresto domiciliario como alternativa?
How long has he lived in Miami?
¿Cuánto tiempo lleva viviendo en Miami?
5 años.
5 years.
Okay. No, I'm gonna give him a bond.
No, yo le voy a dar fianza.
He caused damages to the bank. He may be facing additional charges if the damages to the bank were over $1,000. Then it would be a burglary with damages over $1,000, which is a crime punishable by life in prison.
Sí existe motivo fundado y además él está enfrentándose a cargos adicionales porque si los daños se calculan en más de $1,000 sería un allanamiento con fines delictivos con daños a la propiedad por más de $1,000 y eso sería un delito que puede llevar a cadena perpetua.
Good day, sir.
Que tenga buen día, señor.
So I'm going to take us someplace kind of fun here in a second, but before we go there, let's have a moment and talk about today's sponsor of the show, and that's Aura. our data is everywhere out there. That is the bottom line, whether we like it or not. No matter how secure we try to keep ourselves, our stuff is out there, and we need somebody to fight that fight for us, and that is where Aura comes in. So I got an email this morning from a company called Plex. Now, here at the TCF bunker, we have a library of several thousand at this point videos and TV shows that are all contained on hard drives, and we use a program called Plex to be able to view them on our various devices throughout the home. Well, they emailed me this morning to tell me that they had a data breach incident and that a limited subset, quote unquote, of customer data was retrieved from their databases by the bad actor. But don't worry, that limited subset only included things like emails, usernames, passwords, phone numbers, stuff like that. No big deal. And this kind of stuff happens all the time. Just since I've started talking about Aura, I've gotten half a dozen of these things. But the good news is that Aura is there to help me out because, look, they have all of these things that they offer: identity protection, transaction monitoring, spam and junk removal, antivirus, a VPN, parental controls. One of the biggest things I've benefited from, spam call protection, that's gone way down for me. They do a lot of things. The bottom line is they're constantly scanning the dark web, data brokers, places like that for your data, and removing it for you from those places, or at the very least, if it can't be removed, they're letting you know where it is so you can take appropriate action to secure yourself. You just have to have it nowadays. The bottom line, you have to have somebody in your corner fighting for you because, just as I'm sleeping overnight, there's a data breach and my information's out there yet again, but I know Aura's in my corner. And I'll tell you, they do their job well. I made them prove it to me before I would allow them to partner with this channel, and they have proven it to me. They've removed my data from over 50 data brokers now, places I'd never even heard of. But Aura knows who they are, and that's kind of the point. So here's the thing, aura.com/TCF. Go there. You'll get 14 days for free. There's really no excuse not to give it a go, because within 24 hours, I guarantee you'll see a benefit to it. And at the very least, you can see where your data is, because they'll show you in about 24 hours where it is, and they'll start removing it for you. And at the low prices that they cost after the 14 days, it's worth keeping, but they give you 14 days to make up your mind as to whether or not it's beneficial. So give it a go. You've got nothing to lose. Aura.com/TCF. Don't leave yourself vulnerable online. I don't. You shouldn't either. And we watch enough court. We should know what bad actors are out there. Aura.com/TCF. Okie dokie. I promised you something fun. Whoop, there we go. Let's go to a court we don't often get to see live. This is Judge Brian Oakley. If you're looking for no-nonsense justice, this is your guy. Let's see what's going on.
Yeah. And you understand by waiving, that means the file's going downtown to the circuit court level.
Yes, you told me that's not happening anyway.
Most likely. Yeah. I mean, the standard of proof that the prosecutor has today is a pretty low standard. Yeah, it's not a trial like beyond reasonable doubt. That's a high standard. All right. Okay. So understanding all of that, do you want to waive your exam today?
Yeah.
All right. And you're making this decision freely and voluntarily, sir?
Yes.
Nobody's making you do this.
No.
Okay. I'll enter the waiver. Your arraignment on information date is going to be 2 weeks down the road at 9 a.m. I'll continue your bond and wish you luck.
Thank you.
Thank you. Lowell's up here.
I think other children will be there too.
What's the other name?
Chesney and Parker.
Yep. Chastain and Parker, adjournments. Adjournments. All right, People versus Lowell.
Please state your name for the judge. Playable, LOWER.
Thank you.
Democrat 10, 7, carrying on behalf.
They don't know what, it appears that the prosecutor is wanted to, come in and establish the basis. But Chuck, if you don't mind, I can establish the basis.
Okay.
Is it from the date?
Well, hold on, let me get to it. Sir, did you discuss your rights and options with Mr. Graziani? Understood those rights and the options presented? You understand the possible penalty for the charge? Understanding all of that, are you pleading guilty? Doing so freely and voluntarily today, sir? All right, Mr. Graziani, incident date on the file is May 6, 2023, if you can get me my facts.
Then on that date, you spoke to your wife? Yes. And did you have permission or sure? And, Judge, we've established the basis.
All right, I agree.
A little bit of a background.
Go ahead.
In cases of potential show cause down the road. He's paying a good deal of alimony. There are many messages he's left, but that's neither here nor there. And I told him just to follow the rules, you stay in that over there. Just pay the alimony, right?
Thank you.
And I'm pushing for immediate sentence.
Where do you work, sir?
I took part in Detroit, on Cobble Street.
What do they do there?
I drive flatbed tow truck.
How long you been with them?
8 years.
Okay. Any prior criminal history? And is Melissa Lowell here?
She was in the prosecutor's office. Would you like me to get the prosecutor?
Yeah, I either want her or the prosecutor to tell me she has no input. Yeah.
You order?
Yes.
Okay, you guys can go over it if you want to just bring them in and we'll call you guys up.
Okay.
Do you want to send a better plea form?
I'll make note. Counsel, Mr. Graziani has asked for immediate sentencing on Lowell.
Yes, Judge.
And I understand the complainant was here today. I don't know if she has anything she wants to put on the record or.
Yeah.
All right.
Sit right over here.
She can sit right there at that mic. We'll pick her up. Ma'am, would you state your name for the record? Thank you. What would you like me to consider before I sentence Mr. Lowell?
It's really hard to say because. I thought she was okay, but we need to know cheating there. I thought, cows there, shit like that, but that one was his head. And we came back up to here, went outside, and grabbed me and threw me. I just couldn't believe he would do that. I couldn't believe he'd have that, to look in his eyes, I can't get out of my place. That's scary to me that, and he threw me. Every time I chased in the car accident, when he threw me, because so much stigma after that. I went straight to the hospital, I had to carry my arm because I had no feeling in my arms. Lots of there, yeah, it's taking me back and that. I can't work anymore because my whole spine is so messed up from getting jammed from the fall. I don't sleep at night. I barely eat because I'm just so afraid that he's gonna do something because in the ratio it's something that they hit out of life. So every time for every anything, all I keep thinking about is looking at his eyes when he gets that. And I know this is something who I thought loved me, and I thought, marriage is perfect, but I thought we don't think so. There was nothing in him when you threw me like that. And, it's just, I'm sorry.
You're right.
My partner, like I said, I'll never take a look at my face and feel like that. I didn't think he had that in him. It was a rage that I don't want anybody else to have to deal with. Not that you throw him in jail, but like I said, it's rage I never thought I'd see.
Anything else? You're welcome, ma'am. Anything else? All right, thank you. Mr. Graziani, anything else before I sentence?
Judge, basically, again, the 12-month sentence with the items that are mentioned, putting the fetters, counseling. Obviously, this matter being dismissed if Mr. Lowell successfully completes.
Okay. All right, Mr. Lowell, anything you want to add? All right, I'm going to go along with the recommendation of the prosecutor. I'll do a 12-month delayed sentence under 769.4A. I am going to order the batterer's counseling. I'm going to order no contact with Ms. Lowell. That means no contact of any kind, no phone calls, no letters, no social media contacts. You run into her at Taco Bell, you're eating at Burger King. She has a change of heart and wants to meet for coffee. She can't change this order, only myself or another judge in this building. You understand all that? All right. I'm also ordering do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. Court costs are assessed in the amount of $750. Can you pay that today? Go downstairs and talk options. Any questions from anyone?
No questions, and again, my fast question, I'm sorry about you. No.
All right. Thank you, folks. Are we ready on Bell? Walk slowly, counsel. I'm going to digest this plea form. All right, so Mr. Bell, good morning. Yeah, come on up, Mr. Bell.
Stepped down. He said he'd be right back.
Mr. King just walked on. I just called his case.
No, we're talking Lowell.
Yeah, I'm talking this one. I didn't mention his fingerprints. Get him back in there. Tell Graziani fingerprint order.
Lowell.
Don't think that one belongs to this today.
Mr. Graziani, I neglected to tell Mr. Lowell he has to go get his fingerprints taken.
Understood. Is there anything else, Judge?
Where's that at?
It's Van Buren.
You know where Van Buren PD is?
Yeah.
Can you get there by 3 o'clock today for prints?
Yeah. Yeah, I'll go there right now.
All right.
Okay.
I'll go downstairs first. Yeah, I'll go.
Okay. All right.
Judge, thank you.
You're welcome.
Stay right here.
Counsel, your appearance on Bell.
Good morning, John. Thank you, Miller. You know, reading about 269, so President is my right, you take the next step.
All right. So counsel, it says here, Mr. Bell's going to plead to 2 new counts. One is no valid license on person. We'll dismiss the drove while license suspended. Second is attempt 4th degree fleeing and eluding. And we'll dismiss the original fleeing and eluding, correct? So that would be a 1-year misdemeanor, correct? Okay. Mr. Bell, do you understand your rights and options after discussing those with Mr. King? You understand the possible penalty for these 2 charges? Are you pleading guilty to these 2 charges today? Are you doing so freely and voluntarily? Nobody's threatened you or making you do this? Okay. All right, counsel, I'm showing an incident date of December 9, 24. If you can voir dire to get the facts that support the pleas.
Yes, so, December 9th of 2024, we're in the city of Wayne. Yes, sir. And at that time, we were operating the motor vehicle. And while operating that motor vehicle, did you not have a license on your person? I did not have my also on that day, and in that city, were you approached by officers? Yes. And did those officers ask you to step out of the vehicle? Yeah. And did you drive that vehicle away? Yes. Did you know those officers, the police officers at the time they approached you? Yes. And you heard their orders to step out of the car as well? Yeah. We're satisfied.
I'm satisfied as well. I'll dismiss original count 1, original count 2. I'm inclined to send for a pre-sentence investigation, but I'll let you try to talk me out of it.
Yeah, so they're misdemeanors, he's 19, he doesn't have a record. His mom is here, they have a program ready for him to go right now as far as, employment and education. You know, stay in the city, right now, he's on a personal bond, he's been on bond for a little over a month now, no infractions. I think that's pretty much all.
Okay, all right. What'd you say about employment?
His mom, I think his aunt, I think his mom's sister has found.
Can she wait? You all right if I listen to her? Ma'am, first of all, come on up. State your name.
Chelsea Harper.
All right.
My mom works at Coventry House and
Yeah, I know it.
to do a program, he can get his GED, he's gonna take a class.
Good.
Month long.
Good.
And so she was able to get him approved to go do it. He got a stipend.
Okay.
Go in.
Okay.
Like I said, he's back at home, he's gonna do now, and after this is done, we're gonna get his license valid.
Let me stop you. So I've got an address in E-course. That's yours. Okay,
Doesn't.
good. Yeah. Okay. All right. So you're no job right now? Okay.
Not right.
Okay. All right, counsel, he sounds like he's a candidate for HIDA. Yeah.
And if my was gonna keep them checked out.
Thank you. Yeah, I saw that. All right, Mr. Bell, anything you want to tell me before I set the terms of your sentence? There's no magic answer. You don't have to say a thing. I'm just giving you the option. All right. I'm going to go along with the HIDA for 12 months. During that time period, you stay out of trouble, no new criminal offenses. Get your GED. It's a court order. Within 30 days, I want you to be able to prove to the court that you're working 20 hours a week or more, either a paid job, charity work, or a combination of the two. Understood? Yes, ma'am. No, that's not a job and that's not charity work. Great idea. I encourage him to do that, but it doesn't satisfy the 20 hours. All right. You clear? All right. So that means you have to have documentation. You got to have paperwork, pay stub that says you work 20 hours or letter from the church that says you went in and cleaned for 15 hours, whatever you got to do paperwork. Understood? Well, first of all, you got to get it started within 30 days, right? And then you have to prove to me that on a weekly basis, you're doing that. If you bring it in every couple of weeks, that's fine. But if you don't have that at the end of 12 months, I'm going to look at all the records. I'm going to say he didn't do what I told him to do. You don't get the dismissal. Now, you might not understand how important that dismissal is, but she does. Okay? Any questions, counsel? I'm not assessing any money. So I'll make my tail wag. All right. Good luck with that program. You're welcome. Abu Anwar? Counsel, your appearance.
See you live, move on appearance on behalf of Mr. Anwar, who the sign language interpreter, not yours again. Your fault. You guys have requested it. We just have to pick another date and I believe they come and I think the case is definitely going to be resolved. Yeah, in your point. There is a bit of offer right in there.
And this is the second time the interpreter didn't show up?
Questions of whole time report's been great. You guys are doing your job, that's for sure.
And I received a confirmation for today.
Would you check with Mariah and see if there's another agency?
She'll tell me to reach out to find one, but yeah.
Yeah. So any Wednesday works, but they're gonna be on Zoom until August or October. So if you want, if you want to do live,
With the sign.
I'm thinking it's easier with an interpreter. October 15th?
Yeah, that's fair.
What time, Heather?
That's fine. Thank you. No, you guys are great. Deal with the question.
All right. Thank you, counsel.
Guys, take care.
We'll keep our fingers crossed.
I'll get you a notice in just 1 second.
Oh, we're way over there. So I know. Probably one of the things. Yeah,
Grant?
It's gonna be a dismissal. It's separate 2 o'clock exam. Council on, I wanna see a thing, if it's okay. Oh, would you have a problem with this dismissing over Zoom?
No, but I want to talk to Mr. Grant because he owes us money on something else. So that's all right. As long as he's on, as long as I can talk to him.
But the court officer knows one signs. You know, you're silently, yeah, I do. Also, all your father wanted the bottom now. Nah, you're a funny guy. We have some fun in this business, that's for sure.
We have some.
Yeah, that's good. That's really good. Second time you part of the beautiful. Did a great job.
Yeah, they did.
Something for us,
All right, well, we'll keep an eye on Judge Oakley, and we'll come back to him as he has more contestants. In the meantime, let's go back to Judge McNally.
Mr. Shepherd, you have to have language coaches.
Sir, your name?
Jacob Kelton.
All right, for purposes of arraignment.
Wait for reading my client's statement.
All right, I'm entering a not guilty plea. Now he's going to plead his charge to open intox, right?
That's correct.
Is that what you want to do, sir?
Yes.
That is punishable by up to 100 fines, 90 days jail, costs of all those, and 2 points on your record. Do you understand that?
Yes, Your Honor.
And you understand all the rights on the advice of rights form?
Yes, Your
You
Honor.
did read one and understand one and sign it today, true? If you plead guilty, you're giving up all those rights and we're not going to have a trial. Do you understand that?
Yeah.
To the charge open intoxicants, how do you plead?
Here, Your Honor.
Were you in a motor vehicle on August the 9th of 25 that was on Telegraph near King and Brownstown at 1:09 in the morning?
Yes, Your
Did
Honor.
you have open intoxicants in the vehicle?
Yes,
What did you have?
Beer and twisted tea.
Anybody force you to plead guilty?
No, Your Honor.
Please accept it. Anything, Mr.
Yes, Your Honor. In this circumstance, obviously, my client made a correct maneuver by not driving on that date. However, he should have left his drinks outside the vehicle. In this circumstance, his friend who did pass the PET was driving him. I believe that this case is going to reflect in that case being dismissed. I'm glad he wasn't drinking and driving. Next step is to not have any alcohol in the car. So I'd ask for any leniency.
Anything, sir?
No, Your Honor.
50 fines, 75 costs, 75 victim choice fee, $50 justice assessment, 250 or 30 days. He can pay that now? You work at Marathon?
No, Your Honor.
Where do you work?
I work at TV Deli and Diner.
Okay, how much can you pay today?
I have like $40.
And how much can you pay weekly or bi-weekly?
Bi-weekly, I could do $50.
All right, you pay $40 now, $50 bi-weekly. If you need more time, no worries, come talk to me, okay? On or before any one of these due dates, buy $50 bi-weekly, beginning on September the 19th, okay? 40 today, 50 every other week, starting a week from Friday. Any questions?
No, Your Honor.
You're all set. Have a good day. Good luck.
Your Honor.
J. Edward Clay, 25I-76087A in C. In B, in B, I'm sorry. Your name?
J. Edward Clay.
All right, you guys couldn't resolve this, right?
No, it was just adjourned it so I can get it away.
Okay, Lisa, what do you have, the earliest date with Grosse Ile?
September 20. Can you hear me?
Yeah,
Okay, I feel like it keeps cutting out. September 24th at 9 o'clock.
okay, September 24th at 9, sir. All right, so you can go down the hall. We're gonna give you a notice and you take that paper notice with you, okay?
Where right now?
All the way down the end of the hall, up those doors and all the way down the end of the hall to the clerk's office. Thank you. Thanks. All right.
All right, Judge Oakley's got a new set of contestants approaching, so let's go back to him.
All right.
We ready on Singleton?
Gentlemen, your appearance is on Singleton.
Thank you, Your Honor. Good morning. Steve Thielman on behalf of the people.
And good morning to your honor, court staff, Jonathan Roberts, B 86428 on behalf of Mr. Singleton. Statement in court.
Thank you. What do we got?
Your Honor, with your approval, defendant will plead guilty to 2 counts. He'll plead guilty to count 3, driving while license suspended. And also, Judge, added count 4, added count 4 is a 1-year misdemeanor known as attempt, fleeing and eluding in the 4th degree, and that would be under the penal code, Judge.
All right. And Mr. Singleton, have you discussed your rights and options with counsel? You understand those rights and the options they present to you today? You understand the possible penalty for those 2 charges? Attempt and the drove while license suspended? Understanding all of that, are you pleading guilty to those charges? Are you doing so freely and voluntarily today? Are you doing so freely and voluntarily? All right, counsel, if you would voir dire, give me the facts I need. Incident date, August 23, counsel, if that's what you're looking for.
On that date and time, Mr. Singleton, were you in a motor vehicle? Were you driving that vehicle? At some point during that evening, did you encounter the police? And did the police flick their lights on to indicate that they were initiating stop? And did you disregard those lights and continue driving down the road? At the time you were driving down the road, you did understand that those were police officers. Defense is satisfied.
All right. And at that time, was your license suspended, revoked, or denied, sir? I'll accept the plea to the added charge and dismiss original counts 1 and 2. Well, 3 was the charge, DWLS. So I'm inclined to send it for a pre-sentence investigation unless you guys try to talk me out of it.
This is the first offense. It's going to be under HIDA. I think, this court has it.
No objection to HIDA? Sorry to cut you off, counsel. All right, go ahead, counsel.
Supervision, structure and downtown.
Mm-hmm.
There shouldn't be any issues. Part of his conditions, I think, are they want to be that person to get that license worked on. You can't drive until that license is,
Right.
up to speed. So to say, in terms of fines and costs, his family is here, has a lot of support.
Good.
First, last time they did.
No priors? Okay.
Your Honor, if I may.
Yeah, please.
Especially recommend reporting probation, no jail, under the Youthful phase 6.
Thank you. Mr. Singleton, where'd you go to high school? Graduate? You're in your senior year? What's your GPA? Yeah, and in 30 years on the bench, that means it's not nearly as high as it could be. Am I right? What are your plans post high school? Yeah, what do you plan on doing after high school? Okay. What do you have to do to get your driver's license straightened out? Has he ever had a license, counsel?
I think it's going to take it.
Okay,
I don't know what.
okay.
Just the tickets to cover the
Right.
license.
Is that woman with the head bobbing back there, mom? Sister? I'm sorry to hear that. Can I hear from your sister? Because it sounds like she might know more about your business than you do. Is that all right? Ma'am, come on up. State your name for me. Miss Singleton, do you know the status of his license? Come on up here with a microphone so I can hear you better. You're all right, come on up. Because of too many points? Can you run it? Print it out? He got in enough to see me. That's too much. And that's too much. Yeah. His biggest trouble is because he can't tell me he's doing the best he can in school. I didn't make that kid. And the fact that you're a father is not going to make your life easier without an education. Keep talking off, bud, because I'm getting ready to send you. Keep talking. Keep flapping those jaws. Because you're telling me all I need to know about you right now.
Not having this dad is like, it's wrong. There is a lot there.
Absolutely. And it all sucks. It all sucks. But every day this young man gets up and he gets to make his own choices today. And he's been making bad choices. Keep your dick in your pants. You wouldn't have a kid at 18 without a high school education. Tell me I'm wrong. Smart man, tell me I'm wrong. Counselor, come on up. I can't let you have it, but I want you to look at it because the way I'm reading that, it says he's eligible for restricted right now. But it's been years since I could read those because they keep changing the format and they keep making them worse. I think he's eligible for driving privileges. Would you agree or disagree?
Suspension effective from July. I don't know how long the suspension would last. I'm fine. I mean, as a condition, I would be fine with either saying he just cannot drive without a valid license, and that would kind of solve the issue.
All right.
Your Honor, may I address the court?
Yeah, please.
Thank you, Rob. If he's convicted of suspended license, as you all know.
It's going to, yeah.
Your permission, Judge, I would like to have a plea instead of reckless driving count 2. I think there will be more benign versus driving record.
I didn't know that points.
It's going to be 6 points versus 2. The DWLS is 2 points.
Judge, if I may,
I'll tell you what, hold on. Let's get outside the box a little bit. If you want to be generous,
yeah,
let him plead to allowing an unlicensed driver to operate, which is the same thing you'd give her if she let him drive when he was suspended, right? No points. All right. Won't stop you from straightening his license out. And I'm going to require that he get his license before he's off this HIDA, or I won't give him HIDA. You understand that? So he just agreed to save you 2 points and another suspension period. Yes? When are you supposed to graduate? Mid-year or spring? All right, Mr. Singleton, I'm going to do a 12-month delayed sentence under Holmes Youthful Trainee Act. I'm not going to assess any money. You will report to my probation department on a regular basis, and that could be by email. They'll work that out with you. I'm assuming you can give them transportation a couple times. All right, so as long as you're on track for the first month or two, they'll probably let you just do it on email. I'm going to require that you get your driver's license straightened out before the 12 months is up. I'm going to require that you get a high school diploma before the 12 months is up. And I'm also going to order 30 hours of community service charity work. That means you volunteer with some nonprofit agency that's registered with the IRS, church, soup kitchen, Salvation Army, Boys and Girls Club. I don't care. As long as it's an IRS recognized nonprofit, 30 hours, document those 30 hours. And I want that done between now and December 1, 2025. Do you have any questions about what you have to do to get the benefit of HIDA? All right. Understand, I'm still holding jail time over your head. Make my tail wag or you probably will go to jail. Do you understand that? All right. Now, I have to say this or I will not sleep tonight. Dude, I am glad I didn't have your problems as a kid. But with respect, with sympathy, I want you to hear what I'm about to tell you. The world does not give a shit if your life sucks till you're dead because of the problems you had in your youth. The world doesn't care. Okay? If I had a magic wand, I would tap you on the head and give you a perfect childhood. I can't do that, but I can tell you what I know after 40 years in this business. Dude, you got to make your own future. Your past does not define your future. Your past sucks. I hear it. All right. I'm sympathetic, but man up. Every morning you get up and make good decisions. You work hard. You sacrifice now so you don't have to sacrifice when you're 50 and 60. Because if you don't start doing things better, you know what you're doing? Your child is going to have the struggles you've had. You want the boy or girl? Girl. You want that for your little girl? Hell no. Quit focusing on the past, the things that didn't happen the way they should have, and seize the future, man. All right, I'll sleep tonight. Anything else, counsel? All right, he needs to go down to probation. Sister, thank you.
Okay, real quick. First, that whole speech is going to be a short on this channel sooner rather than later because I loved it. Second, especially for those of you who are members who listen to me in the pre-show, which, by the way, if you're not a channel member, fix that today. You get early access to videos, you get a discount in the store, you get access to the pre-show, a whole bunch of stuff. And it's only $2.99 a month, so I don't, it's not about the money. It's just about you being part of what we do. Anyways, for those of you who especially hear me talk on the pre-show, tell me that Judge Oakley is not my spirit animal. He preaches a lot of the same things I do, probably better because, he's got the attitude behind it for sure, but I enjoyed that. All right, we'll wait for the next contestants for him. Let's go back to McNally.
My name is Rahim.
You have a charge of leave the scene of a property damage accident. You have the right to a lawyer. Do you want a lawyer?
No, I do whatever you guys are giving us anything so I can find a lawyer because I was working there.
Slow down. I just want to know right now if you want a lawyer.
No.
Do you want, I can go ahead and arraign you? Is that what you want? I'll explain the charge and the penalties and then you can go talk to the prosecutor. Is that what you want to do?
Yes.
Okay. On August 23rd of 25, the police think you were operating a motor vehicle on Daylily Drive near Azalea in Brownstown at 1:03 in the morning, and they think you left the scene of a property damage accident, that you were involved in an accident and left. That is a misdemeanor. It is punishable by up to $100 in fines, 90 days jail, costs or all those, and 6 points would be added to your record. Do you understand that?
Okay, so this one was it door dashing?
No.
Okay.
Don't talk about it.
Okay.
Don't talk about it. I want to make sure you understand what the possible penalties are and what they think you did wrong.
I did wrong, so I can.
Listen,
Okay.
do you understand what they think you did wrong? That you were involved in an accident and left?
Involved in an accident, yes,
Sir, do you speak fluent English?
Yes.
Okay. I just want to know now, do you understand what they think you did wrong? That you were involved in an accident and left the scene without calling the police?
Yes.
Do you understand? I'm telling you the maximum penalties, the maximum, the worst. I have to tell you what the worst thing is that could happen.
Okay.
Do you understand the possible penalties? Up to 100 fines and 90 days jail and costs? Do you understand that?
Yeah.
All right. Did you read this advice of rights form and understand it?
Yeah.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand it?
Yeah.
All right. You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea. I'm giving you a $500 personal bond. Okay? You don't have to post any money,
Okay.
but you have conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You understand all that?
Yes.
We're going to give the file to the prosecutor. This is Brownstown. You're going to go out in the hall and she's going to come and talk to you, get you and bring you back to the conference room and speak to you about this case.
Okay.
Okay?
All right.
All right. Any questions?
Thank you.
Best of luck. Thanks.
Have seen, oh,
Okay, I'm sorry. Shamard.
Okay, new set of contestants over with Judge Oakley, but I've got it paused for a second just because I think how Adrian Grant is presenting himself at the moment is funny. Heaven help him. Let's see what happens.
He needs to jump on Zoom. All right, bye.
While we're waiting for the prosecutor, Mr. Grant, you owe us money on some tickets, a distracted driving and no proof of insurance from 2023. The city of Romulus issued the tickets. Total on those is $654. Are you in a position to set up some kind of payment plan, regular payments?
Yes, sir.
How often, how much, and when can you start?
Weekly.
How much?
I can start weekly, about $50 to $100.
Let's start at 50. You can always pay extra. When can you start that?
I can start next week.
Next Friday or work for you?
Yes, sir.
All right, that's the 19th. Mr. Lecky, we got you yet?
Yep.
Thank you. Appearance on the People versus Grant file.
Yes, good morning, Your Honor. Jacob Lecky appearing on behalf of the people, P88400.
Once
again, Eric goes on behalf of Mr. Grant, P number 60310.
Thank you. What are we doing today, fellas?
Your Honor, I know today is set for exam. We have reached out our office to the complaining witness. She indicated that she is not wanting to proceed today and she is not coming. Therefore, at this time, Your Honor, we are unable to proceed, and I think defense has a motion. Move to dismiss, Judge.
Dismissed without prejudice.
Thank you, Judge.
Thank you. All right, have a good day, gentlemen.
Take care, Mr. Grant, and take care of those tickets, okay?
Thank you, and I will. Thank you.
Are we ready on Bridgman?
Yes. Thank you, Judge.
Ms. Frosch.
Good afternoon, Your Honor. Teresa Harper, appearing on behalf of Mr. Bridgman. Mr. Bridgman, will you please state your name for the record?
Thank you. And Mr. Bridgman is going to plead to improper transport 750.227. Is that correct? I think that's a 1-year misdemeanor, correct? You understand that, sir? Possible penalty is up to 1 year. I could put you in jail for a year. I have to tell you what the possible penalty is. I'm not planning on putting you in jail. You understand that? Did you read or did you go over your rights with Ms. Farage?
Yes.
You understand the rights and the options those rights give you?
Yes.
Understanding that, are you pleading guilty to this charge? Doing so freely and voluntarily. All right, counsel, can you get me the facts I need to support the plea? December 20 is the incident date.
Yes. Do you mind if I grab this for?
No, not at all.
Mr. Bridgman, on the day of 12/20/2024, reading in the location of 274273 Road, Romulus, Michigan. And that is in the city or the county, the state of Michigan. And at that time, you were stopped by, or you were stopped by Romulus Police Department?
Say again? I can't hear you.
I'm stopped on Pennsylvania Road.
I'm asking.
By which department? Thank you.
And at the time, when we were stopped, he informed officers that there was a firearm that was inside the car.
Yes.
And where was the firearm located?
See.
And, at that time, you didn't have a CPF authority.
I'll accept the plea, dismiss count one. All right, immediate sentence? Okay, are you working?
Yes.
Where do you work? Kroger's. How long you been there?
I've been there the last 3 months. Right before that, I was at FedEx. I sued over Kroger.
All right. How long you been driving?
Last 2-3 years.
Okay, no CPL?
He didn't bring to the court a certificate of completion of the CPL class. He has a,
So he's in the process.
he next gets an appointment, so I.
Good. Good. All right, any prior criminal history? Okay, why you got such a bad attitude today?
Upset.
Okay,
The whole process of advising it was real weird and.
okay. Right. Get over being upset because this is a pretty damn good result. This is so much better than a felony, brother. So much better. Felony probably cost you your job. Would it?
Yeah.
Yeah. All right, anything you want me to consider before I sentence you? All right, 12-month non-reporting probation. That just means stay out of trouble. No new charges. Court costs or fines of costs assessed from the amount of $500. Can you pay that today or do you need options? Go on downstairs and talk about the options. They'll straighten you out. All right, what's next?
There's the setting it for examination.
Roberts?
Yeah.
Isn't it set for an exam? Is it an exam today? Ah,
We gave it late.
oh, yeah. Counsel, I think we already gave you some October 15s, or was it 22nd?
Yeah, Your Honor.
15th? What time? How about 1? Mr. Roberts, October 15th, 1 PM? Bond continued unless I hear otherwise?
Okay.
All right, Mr. Roberts, just have a seat back in the pews. We'll get you a written notice. You're welcome.
No, well.
Mr. Kaplan, anything for me?
Not at this moment.
All right. Keep pushing. Yeah.
Let's see a lot. I think we met.
It's been a long time if we had. That was a McComb prosecutor, so I don't know each other. No, I never went to McComb. I know we've met. Yeah.
Well, welcome.
You do a nice job. Thank you. I was with Wayne County, you might remember, in the homicide division, way back. I know you know all these.
Yeah.
2011, 12, and 13.
Yeah.
So I came back.
So where they have you? You just like filling in?
Simon,
Okay.
I'm in Detroit some days, and
Okay.
just happy to be back.
Yeah.
Nice to see you.
It's good to work when you want to work, right? Yeah. Yeah. Good to see you.
See you.
Mr. Graziani, what do you have?
Getting an adjournment from, your staff, so.
What's the file?
In fact, that is the plea. No, there's an adjournment. That was the plea off of that because I mean, more than the trustee words.
Give me a defendant's name so I can pull the file.
What's that?
Defendant's name.
Other than that, Logwood.
Logwood.
He agreed, but let me go with, yeah, I need something. Yeah.
That's all you have to do.
I'll bring you.
Ready for
Hey.
Hey. Stops recording. That's all right. Just nice talking.
Miss Elijah, you got something? Give me a name.
Wiley.
All right, looking for the file. Got it.
Wiley, with your permission, the people are unable to proceed on count 1 with missing our complainant.
Are you gonna-
Court, this count 1 without prejudice, and keep count 2 here at the district court, because we do have a witness who's cooperating.
Okay. All right. And Miss Elijah, I'm going to guess you're not on our, you can sit down, sir. Yeah. I'm going to guess you're not on count two.
Well, there's a felony in the case. So
Right. I'll set it for pretrial. You can deal with our MIDC. Okay. You understand that?
So you go ahead and ask, when the next court date, and is it Zoom or in person?
Yes. Heather will tell you.
How many weeks out? I think, well, he's gonna need is the attorney referral gonna happen today, or is it gonna happen at the next court hearing?
At the next court date, he'll speak to somebody.
I suggest that, sooner rather than later.
Then we have September 24th, 2 weeks, 9:45, and that would be by Zoom.
Okay, yeah, September 24th at 9:45.
Is that Martin?
That is Patton.
All right.
No, we won't, because
Just leave bond as is.
This is the case we argued upon last week with the 99-year-old mother. Michael is the
Yeah.
one who they lived.
I got you. You had me at hello. I remember. Yeah. Yep.
Michael, the count two is Randy, who's here.
Right. Randy, where are you? Randy. Would you ask Randy Wiley to come in here?
He does.
But not the house. I mean, not the address. Yeah. Okay. And I already removed the not to return to. I did that last week. So unless he gives me something, I'm just going to continue bond.
He should have no contact order with Brother Michael, because Brother Michael is the
True, that case is dismissed. You got that?
I will whenever, yeah.
Yeah.
Would like to sit down for the,
Yeah.
that part of it.
Your name, sir?
Wiley?
Okay, so currently there's a no contact bond. We're going to continue that.
Yes.
Anything else?
I don't know.
To appear and testify. I don't know what the process is.
Okay, so we had two counts, one with your brother Michael, one with you as complainants.
Yeah.
The count one case has been dismissed today. We're scheduling the count two, your misdemeanor case. That's going to be scheduled on September 24 because this attorney can't represent him when that's a standalone case. So we've got to get him a new attorney for the misdemeanor. Just the way the system is.
May I ask, how did it go from a felony to a misdemeanor?
The prosecutor just said they were unable to proceed with the felony and dismissed it.
Prosecutor said this?
Yes. All right.
Can I talk to the prosecutor? What?
Well, that's up to the prosecutor. You can't talk to him right now though, because I'm using him on other files, but right. I can't tell you because it wasn't my decision, but I'm sure he'd be willing to talk to you. He just wait for him until he's done in the courtroom. All right. That's Mr. Kaplan right there with the vest. All right. Thank you, sir. That's all. Thank you. All right. So pre-trials 9/24/25 at 9:45 in the morning with Judge Patton by Zoom. Bond is continued.
Thank you, Your Honor.
You're welcome. You had another file. What's that?
It is last week.
All right. Joe, do you know that? We're gonna give you notice, Mr. Wiley. Okay, you're all right. I'm sorry, Mr. Elijah. Was that Martin? The next one? What are we doing?
The officer is, personal knowledge is not here.
All right. Both counts?
Sir, if I may, we do have a witness, but not the game where I can't prevail without us.
Yeah. Unali Prasen?
We would, we'll reauthorize charge to give us.
Okay. All right. So I'm taking that as a motion from the fence to dismiss. All right, so I'll just leave it to you to explain that to Mr. Wiley when he gets in, and then we'll get him on his way back to get processed out, hopefully.
Oh, Mr. Martin?
Mr. Martin.
We can bring him on.
Okay. I probably can't call him off now. You're gonna take him right back in, Joe. He's going right back in. We're gonna dismiss if she's just explaining what happened.
And I was in the front where smart and sober over 1 year.
Good for you. Good for you. Now you know how it works. Yep, good for you. Keep it up. Keep it up. What do you got?
We're ready, Nielsen, like.
Nielsen? Are we holding it?
So,
All right. I think we got 3 different files, don't we? 2 different, yeah, 3 different files.
He doesn't have anything to do with the 2 graphic offenses. They're misdemeanors, so the NDS.
Oh, thank you. Thank you. Thank you. What the hell? We got one of these. This got a C next to this. Civil infraction. We'll put them in file.
No, it just means that they didn't pay attention to what file they.
Failed to stop them through distance.
Yeah, it says SI, it should be an orange file.
I would mind, yeah, this. And you all in my personal phone.
Ms. Farage, we ready on Nielsen?
Thank you.
Oh, you're welcome. I hope that young man hurt my heart, counsel. He is so lucky, man. Right? If you don't have family, what do you got? That's the problem with being young, though. We don't usually notice our blessings when we have them. I'll wait for him.
Yes, we're ready, like,
All right, appearances on the People versus Nielsen.
James Blanky appearing on behalf of the people, PA 400.
Good afternoon, Your Honor. Currently, some more provided on behalf of Mr. Nielsen. Can you please introduce him for record?
Have a seat, Mr. Nielsen. All right, we ready?
The people are ready back, but I do want to put on the record. So I know last week you're here for discovery. It occurred to me that a personal issue came up with the detective. We have sent this up. So here's what happened. I was at Romulus or Van here yesterday to personally get discovery. Well, I was there for other things, but
Right.
Station. And I sent it over by 1 p.m. I believe that's when I sent
It was like 2
2 o'clock.
Yesterday afternoon.
And it occurred to me, you know, I've been asking for it the day we left, Shakespeare.
Right.
I also emailed on Friday about it. But a personal issue came with Mr. Harrison. I don't know if the court is aware, but
I'm not. No.
But so it didn't get to council till here. That's just what I.
Then you can refile
Your Honor, we're gonna move to this one.
without prejudice, which means they can refile if they want to. Understood? All right, you still got some misdemeanor stuff we got to deal with. We've got failed to stop property damage accident, and then we've got a civil infraction, failed to stop assured clear distance ahead. Were those scheduled today? Or they're just tagging along? I'll give you the choice. You can wait until the attorney that's here today, that guy right there that just walked in, has time to talk to you, or I'll let you come back because I know you've been here most of the day. No, I'm giving you the option. If you want me to, I'll just give you another date on these. Okay. I'll even let you pick a Wednesday. Pick a Wednesday. You want to come back next week, 2 weeks, 3 weeks? I don't care.
2 weeks.
24th?
In 2 weeks, because I've been here every week.
No. I'm letting you pick, brother. Okay. Just have a seat in the pew behind you and we're gonna get your written notice. He does that, adjourn me to the phone call. Oh, hold on. I think I wrote.
Hey, sir.
I think I wrote unnaturally dismissed.
Okay. You're already, but.
Okay. Yeah. Mr. Roberts, what do you got? What are we doing? I'm sorry? Is this yours, Mr. Lecky?
Get minutes go, get it.
Quickly. Yes. Okay. The family got my nephew up to second place. I don't know what they get, probably just a recognition.
Is Mr. Graziani on Tansy?
Yes.
Thank you.
Mr. Johnson, while we're waiting for the prosecutor on your felony file, my records show that you owe us some money on a 2023 misdemeanor out of Sumter, $149. Allowing an unlicensed driver to operate a vehicle.
I do believe I remember talking about, Your Honor. I had it, being garnished from my income taxes. I defeated,
Probably didn't pay it all off. Are you in a position to make some payment arrangements on that?
yeah, not at all.
No, that's all right. We'll take payments. Can you set something up before you get out of the building?
So 100.
Our records show 149.
Okay, we're in the Wayback Machine here just a little bit, so I'm going to try to bump this forward to speed along the prosecutor here, so hang tight. All right, let's try this. Oh, no, now the judge is gone. Okay.
All right, we'll blame Heather. Go ahead, counsel.
Count 3 would be attempted fleeing and eluding in the 4th degree. As the court knows, that's a 1-year misdemeanor.
That is correct, Your Honor.
And what are we dismissing?
Counts 1 and 2, Your Honor.
Which are what?
Fleeing and eluding in the 3rd degree. And driving while license suspended.
It's Gutierrez.
Gutierrez Hummer.
There it is. All right. All right, Mr. Gutierrez Hummel, did you discuss your rights and options with counsel today? You understood those rights and options? And you understand the possible penalty for the added count? Understanding all of that, are you pleading guilty to the added count today?
Yes.
Are you doing so freely and voluntarily?
Yes.
Counsel, would you voir dire incident date August 31 in the Township of Huron?
Mr. Humble, I'm gonna take it back to the date of August 31st, 2023, okay? Were you driving, highway I-65 southbound Huron Road? Is that in Huron Township? That's in the county of Wayne?
Yes.
And as we were driving, you noticed that the Huron Township Police were behind you.
Yes.
They were in a marked squad car, correct?
Yes.
You knew that they were police officers?
Yes.
And they attempted to stop you, correct?
Yes.
And you failed to obey the command of the officers?
Yes.
Understand?
I'm satisfied. I'll dismiss counts 1 and 2. What's the status of your license?
It was reinstated.
Awesome. All right, you working?
Yes.
Where at?
2 jobs.
Which one have you had the longest?
I'm sorry.
Which one have you had the longest? How long?
2 years now.
What's the other job?
In a dispensary.
Okay. How long?
It's been 2 months, almost 3 months.
Okay. Any criminal history, counsel? What else should I consider?
Your Honor, since 2023, this happened about 2 years ago. He hasn't had any of the arrested with the felony contact with the police, but he said he got his license reinstated, so if the court had no objection to moving to immediate sentencing.
I do not. Anything else either one of you want to tell me?
Nothing further from the matter.
All right. Mr. Gutierrez, I'm going to put you on a non-reporting 12-month reporting. That means I'm just hanging over your head for 12 months. Make sure you're staying out of trouble. Court costs and fines assessed in the amount of $750. Can you pay $750 today or need options? Talk about that downstairs. Any questions?
Thank you, Your Honor.
Good luck.
Hey, Greg.
You're welcome. Are we ready on Johnson? Is that Mr. Lecky's?
Oh, did you check?
Yeah, all right.
I don't know if I got appearances yet.
Might be bringing on the people needed towards you.
And good afternoon to your on-court staff. I'm Roberts of the 86468 on behalf of Mr. Johnson. My left, Mr. Johnson, can you please say the full name of the court?
Joseph Corey Johnson.
Thank you, gentlemen. All right, let's get started.
And so before we begin, I just want to put something on the record.
Go ahead.
It's my understanding that there was a CPS review of any witness and a child in common. I have some reason to believe that there was a statement by CPS workers relating to the incident. Some of that may be exploratory, some is in anticipation of this demanding to the prosecutor hand over any CPS interviews notations related to this incident.
And Judge, to respond, so CPS interviews are confidential. I have no ability to ever access or subpoena CPS records or personnel. So I mean, I think the way that they would have to do is through a discovery order. I just don't know if it's ever. To be honest, I don't think the people in that or the defense team said we should have those.
And I just want to preserve it for stand away.
You preserved it. Okay. Anything else, fellas? All right, let's call a witness.
Clark Kristen calls this in,
I'm sorry, say again. Fallon? Just Fallon all the way up front. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Watch your step on my ramp right here. Have a seat in that chair. When you're ready, Mr. Leckie.
Good afternoon, Ms. So do you know Joseph Johnson? How do you know?
He's the father of my two children.
You might have just seen that microphone so you can speak right.
Yeah, he's the father of my two children.
Okay. So it's fair to say that if you were to see him again, identify him. Please, is he in the courtroom today? Can you please point him out and identify him as someone he's wearing?
Noted.
Now, so on a 8/18/2025, were you at a 5160 Play Road in Sumter Township?
45160, that's.
And were you there sometime in the afternoon? And was the defendant there with you? Tell me what happened.
He had left to get milk. Came back. And. Sorry, I just need to. He came back and sat on the couch and I was facing away from the living room. He was facing the opposite way, that we go from the living room. That if I were to try to see his glasses off, or that if he were to see something else that he had, I couldn't get his glasses off of his skin. Because I had done that prior to him going to get him. And.
No, I'm gonna stop you just there.
Go ahead.
So you said that, so your testimony was that he said, I bet you can't grab your breast. Is that? And why is that?
Because prior to him going to get milk, I had told him that we didn't have any milk and that he should go get it. And then I said, no, he probably shouldn't because you've been drinking. And he said, okay, fine. And he was already at the back door. And he said, you go up to get it. And he threw the card at the back of my legs. So then I was like, okay.
So he threw a card at the back of
The EBT card. And I said, okay. So I bent over to get the card and grab it. And he literally ran from the back door to grab the card and grabbed it at the same time as me. And he grabbed my hand and the card at the same time and was squeezing it where the card was cutting in. And I asked him to please let go, leaving the card back with my card. And he said, he looked at me with a hateful stare and he said, I'll always win.
Well, I'm gonna stop you there. So did you give him permission to grab everything?
No.
Now you said he looked at you with a hateful stare.
He would not let go of my hand, so the only thing that I knew to do at that moment was rip his glasses off of his face. I did break them.
And why did you do that?
Why? Because I was trying to distract him to get my hand bruised.
And did that happen?
Yes.
So, and that was before you, correct?
He left even though I asked him not to with my card while trying to throw a quick story that incident.
And he came back. That's when this session happened. Where that you can't grab my glasses off, correct?
Yes. I was trying my best to avoid him. My back turned to him. Did not talk to him. And he came and sat on the couch in the living room. Didn't say much of anything. And then out of nowhere, he said, I bet if I went to go grab something else of yours, you couldn't get your spare glasses off of my face. He had a second spare pair on.
So what happened?
I said, please don't do that. I don't want to do that. But I said, if you grab something else of mine and I have to get it, then I will grab the glasses off of your face again if I need to. But I said, don't make it happen. Like, I just want to be left alone. So then I proceeded to grab my Bible case off of the counter, walk to the other side, the opposite of the living room on the bigger couch. He was on the shorter couch. And I audibly said, I need Jesus. And I sat down with my Bible to my left. And he said, yeah, you do. He stood up and grabbed my Bible, came over and grabbed my Bible and stood in front of me. He had beef jerky in the left hand and my Bible in the right. And he said, I bet you can't get my glasses. And he was like, come get them. Like, just basically challenging me to get them. And
What
when I asked him to give me my Bible back, I said, I don't want to do that. I stood up and I tried to grab the Bible from him, and he would not give it to me. He said, get my glasses. So I did take his glasses off of his face. After I grabbed the beef jerky from his left hand to try and distract him again, trying to joke, and he said, oh no, my beef jerky. I'm like, just sarcastic. And then I tried to grab the Bible again. He still wouldn't give it to me.
So just for clarification, so you.
Sorry.
You're good. You're good. We just have to.
Yeah.
Make our clear.
Great.
Okay, so you grabbed your Bible.
Yeah.
Testimony is that you would not grab your Bible then.
I attempted to grab it back. I said, please give it back to me.
And then after that point, that's when you did the beef jerky.
Yes.
Then
It still
after
didn't
that-
work. He still had it. And then I took his glasses off his face where they were already taken single. They broke apart again and he lost it.
And so when you said you lost it, what happened?
I would say that he went into a rage.
And by you went into a rage, what was that?
He looked over and he saw my phone on the table. And I knew, like, just by knowing him, that he wanted to pay me back somehow or.
Objection, just that's speculation. I just.
Any response?
Actually, don't think it's speculation. I think it's based on her prior dealings with them, and it's just her interpretation of what was going to happen.
Well, I think based on prior dealings would by definition make it speculation.
Understood. What happened?
I'm sorry, what was the last thing?
So you were going after.
I went to grab my phone and grab it, well, I went to grab my phone and run away from. And he proceeded to chase me and attack me at that point because I didn't use.
Okay, so what do you mean by attack?
He tackled me to the ground.
Okay.
And he put his arm around my neck and bent me backwards and bent my neck backwards. And
So I'm sorry to stop. So is he on top of you?
yes,
Now, and you demonstrated a gesture that one of your arms was bent and that.
that is
the-
his arm.
Okay, yeah, so you're demonstrating that his arm and his elbow was around your neck, is that correct?
As long as it is.
I didn't think it was, okay, so. And what happened after that?
He continued to hold me tightly in that way, and I could not breathe.
Now, when,
Spots.
so you were seeing spots, what else was happening to you?
I was clutching the phone through my chest, trying to get it to where he didn't grab it. Because that stops me from being able to call anybody as relation. So I was clutching the phone to my chest, and he was, I guess, using the choking thing to try and get me to let loose of it.
So.
And I tried to get him.
Sorry. So, I want to go back to the strangulation before you go.
Yeah.
So, you were saying that he was, you were seeing spots. What else was happening?
I could not breathe,
Okay.
and I was trying to yell for my daughter, but I couldn't. My airways restricted.
Okay. Did you have any like flames in your head, any hallucination stages?
Yes, my head could not breathe. I was very concerned for myself.
And then, so you mentioned while you were down, you hit, is that correct? Like that you up, what were you saying?
Yes, so I was on my belly, and he was on top of me from the back, had his arm around my neck, choking me. And the only thing I knew to do was from behind, try to reach him with my heel, reach like the back of his balls, and that's what I did. I barely clicked him, and he kind of like nudged a little, and I got free just for a moment.
And how did that confrontation?
The conversation total, like, he ended up getting my phone and calmly sat up and smashed it about 6 or 7 times on the corner of the coffee table, and then calmly handed it to me and said, "There, my inspired arrest."
So he smashed your phone, correct? Do you know how? What kind of phone was it? Do you recall?
Note 9 Galaxy.
And do you know About how much it costs?
Actually, no, I just, it was about 200 something, but he did purchase that phone.
Okay. So we did.
Yes.
Oh. Right. But I didn't know any further this was.
Mr. Roberts?
Good afternoon, staff. So I'm just gonna be asking some questions. If you ever need to repeat, slowly on rephrase it, let me know, okay? And then also, just for the record, nods and head shakes just won't be picked up in the court reporter, so say yes or no, okay?
Okay.
Thank you. So can you please walk me through who is living in the house of yours?
My uncle and my future husband.
Now,
Counsel, I'm sorry, counsel. When you say at this time, like today or at the time of the incident?
so just to clarify, I'm spelling at the time of the who's living in?
Joey, my uncle and my three kids.
Were any of them all in a Simpson family?
My three kids.
To your knowledge, were they in Rome for the time?
Yes.
So that was I will get into the application you talked about. So there's a dispute about getting them, right?
Not about getting, well, yeah, around getting. About who should get it.
Or we should get it. So it's fair to say it's not the first time you all have had disagreements about things like getting milk or household tasks, issues.
We have a little bit.
At this time, are you separated or still together?
Separated, we get separated at the same time.
Okay. But you all are still living together?
Yes.
And this is, to be clear, this is your office house?
Yes.
And obviously, post breakup, you didn't necessarily want this to come to the house.
It was right after, no, I did not prefer that.
And there were some attempts leading up to this incident to get him out of the house.
Yeah, I'm gonna object this time, I guess, as to relevance. We're going from that way.
No, they're not.
Hold on.
And sorry, so Ms. Allen, if there's ever an objection, don't answer, because I don't want you to necessarily put something on record. So Judge, this goes to credibility and bias. I think if she has a motive to potentially represent things.
I'll allow it. I'll allow it.
I think we said no.
She did say no.
Do you have any knowledge of any eviction proceedings going on right now?
Yes.
And those are still ongoing.
Yes.
And to be more specific, those eviction proceedings are to get Mr. Johnston out of your office.
Yes.
And one thing that you said that the ET car was cutting into your hand, did you sustain any injuries when the car cut into your hand?
Yeah.
Was that documented by police?
I did it first. It was more of an indication of some cause.
No, thank you for the clarity. And out to the legal.
They arrived and I had called. They arrived around, I think it was 3 o'clock.
So about how long after the incident, would you say? And did they take a statement from you?
Yes, they were on.
And at some point did CPS come to the house to investigate?
They do.
Did you give a statement to CPS?
I do.
Did your
I didn't
initial
get the red.
It was the purple.
Yes,
Thank you. Did your children ever give a statement?
yes, my earlier,
You were the only one?
yeah, but she's 5 now, there's the other one.
Thank you. And so the police get there 20 minutes after, they offered to transport you to the hospital.
No,
So the police never offered you any transport.
no,
Did they offer you any medical attention?
no,
Or you just take pictures of the injuries?
that was supposed to be the day after. Then I,
Did police ever go and ask for medical, or if you're saying they didn't have well?
they didn't offer to take him to get checked out or pull anyone out, they did not.
I'm very sorry for that.
Sure.
Thank you, Sal. Nothing further.
Any redirect? You can step down. Watch your step on the ramp.
And judge, people have no further witnesses for the consent process.
Any witnesses from the defense? I am ready for closing arguments or arguments. Thank you. Ms. Roberts.
Judge, I think it's clear that there is some ongoing relationship issues here. We're at a point in their relationship when it happens that they're broken up and Mr. Johnson is still in the home. Obviously, that is not ideal for Ms. Fallon. I understand that things as small as milk can lead to disagreements and altercations. What's important to know is the first time in which I'm seeing assault happen here is when she rips the glasses off of his face before, he goes to get them. I'm understanding that they're both trying to pull out an EBT card. I wouldn't consider that to be an assault. I think she assaults him first. When he gets back, he is in, obviously, because his glasses were broken, he had a tape on. You hear Ms. Fallon, I appreciate her honesty, that there's never a point at which, she's not initiating that physical contact first. If it's taking his glasses off again, I understand that you might have disagreements about the Bible, about the Jersey, but there is physical contact unwanted on the part of Ms. Fallon that is occurring towards Mr. Johnson. And ultimately, if he purchased the phone, he has the right to break the phone. So that's not excuse enough to then get into a tussle. He's trying to get his phone. And he's being struck in the genital region. I think this is important. I mean, because it's a third, we can't get into, necessary self-defense at this stage, but I don't see enough here for GBH or strangulation. I understand that the argument is going to be that at the point where Mr. Johnson allegedly has his arm around her throat, I don't see, even at the probable cause level, reason to think that this is worthy of GBH. I think it is a deep third. That should be litigated, of course, because if Ms. Fallon really didn't get any medical attention, we should get into that a bit more, but I don't think we're at the point where a GBH is necessary. So I'd ask if that can also specifically be dismissed, and then the balance will address it.
Mr. Licking.
So, Your Honor, was her testimony. Well, I'm not explaining what you said, but
Thank you.
essentially, she said that she was to the point where she was starting to speak dots and couldn't breathe. I mean, that's strangulation. As to the assault, I mean, I don't think it's fair to say that squeezing her fist is not an assault. But That being said, that's not really the DV third anyway, or the strangulation. Some time goes and passes while he goes to get milk. When he comes back, this whole "I'm gonna take your Bible and then dare you to grab my glasses" thing starts. What I guess is that maybe the strangulation is self-defense of the glasses, which I don't believe is proportional force, so it wouldn't be self-defense either. But I think there's enough evidence to show, at least at a probable cause standard, that this is the defendant who was on top of the victim and strangled her with the crook of his arm to the point where she couldn't see.
Thank you. Mr. Roberts, anything else? I'm not satisfied at all with all the nicest way I can say it is game playing and button pushing, but I think there's enough here to bind over. AOI date will be 9/24, 9 a.m. Everybody satisfied with the bond as is? Let's make sure we're all on the same page. Looks like it's a 5,000, 10% with no contact and don't return to a certain address on Clay. All right.
Your Honor, incidents that the complaining witness is present for, and she can come back and testify to if he needs, but essentially the allegations are on 8/31, the defendant sent her a text message of a Facebook link of a picture saying moms of 3 or more stressed. That I'm not as concerned about, and we just ask the court to in either way, just reiterate what no contact means. Secondly, on 9/4, a mutual friend called with the defendant in the car, stating to the victim the following: we're sitting here trying to figure out how to stop the defendant from going to prison. She proceeds to immediately hang up once she understands what's going on. I saw the call log, it's about 21 seconds, so that stands up. And there are 3 more times in which, in quick succession after that, where that third party with that friend falls with the defendant still. So, Judge, we're going to ask just to reiterate what no contact.
Understood. Understood. All right. All right, Mr. Johnson. No contact includes no social media contact. It also means you don't encourage anybody else to talk to her about this situation. Understood?
Understand, no contact, period.
Okay. All right. Good luck downtown.
Thank you.
Okie dokie, friends, that brings an end to today. I hope you had fun. I found today to be one of the more enjoyable ones that we've had recently. Good court. Some real raw but truthful statements from Judge Oakley, to be sure. Like I said earlier, I think he's my spirit animal, to be honest with you. But we don't get to see him very often live, so that was a good treat, I think. We will be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. If you're not a channel member, you should consider becoming one, seriously. It's a whopping $2.99 a month. Not a lot, but you get access to the pre-show. You get early access to the 3 videos we post every day, a sizable discount in our store, all sorts of fun stuff. So do give that a look. And quite honestly, you get deeper access to the best community in LawTube. And I don't just say that because this is the channel I run. This is a really good group of people, so join it, definitely. But yeah, like I said, we'll be back tomorrow. And in the meantime, go make yourselves a great day and enjoy what you can, because we don't get many days in this world. So make the most of each one. That's my advice for you today. Take care. God bless. See you tomorrow.